So we have panelists seated now. This is, as I said yesterday, the panel on indigeneity has been moved to this hour. We have Harry Hobbs, who is a PhD candidate at the University of New South Wales Faculty of Law. We also have Natsu Saito, who is a distinguished university professor at Georgia State University's College of Law in Atlanta. And we have Kenny Yoshida, who is on the Faculty of Law at Hokkaido University and is an expert on the reparations regarding the Aino people, the indigenous people in Hokkaido. So we're going to begin our panel now. Thank you.
Thanks, Robert. And thanks to the GAM family and everyone who's helped out organising this conference as well. It's really a pleasure to be here. If we're holding this conference in Australia, I'd begin today by just doing an acknowledgement to country, which is where at any public gathering, at any public gathering, we would start by saying that we acknowledge that the land on which we meet is the traditional land of the native Australian people, or the Native American people here, and we'd pay our respects to their elders past and present. And so I'll do that just for the Chitimaka people, who this is the traditional land on which we eat, and so I pay my respects to their elders past and present. Today I'm going to talk about 3 points. So it's divided into 3 sections. First, I'm going to provide a bit of background on a recent push in Australia to respond to the continuing injustices of invasion and colonisation. The Uluru Statement from the Heart, which I think I've handed out to most people. If you have one, or if you haven't got one, they're going around a little bit. The Uluru Statement from the Heart is a powerful call from the First Nations of Australia for meaningful structural reform to state-sponsored atrocity and dispossession. And significantly, my colleague on the paper, Megan Davis, who unfortunately couldn't be here today, designed and led the process that resulted in the statement. So she's been really a driving force in the pushes for constitutional reform in Australia. Next, I'm going to talk a little bit, quite briefly, I guess, on the importance of truth-telling as revealed in the Uluru Regional Dialogues. This is kind of the processes that were designed by Megan, kind of a bit like the direct democracy concentric circles that were discussed yesterday to some degree. So it's interesting to see how these ideas are really percolating across the world. And also the value of truth and truth commissions to processes of transitional justice more broadly. This discussion will be relatively short though, because it leads to the third and most substantial part of my talk today, which is how could a truth commission be designed in Australia? The key point here is that notwithstanding the recent Canadian Truth and Reconciliation Commission into Indian residential schools, as we heard yesterday, by and large, truth commissions and transitional justice mechanisms more broadly are not designed for liberal democratic settler states, or that while potentially undergoing a moral transition, are not undergoing a political transition. This means that substantial thought needs to underpin the design of an inclusive and effective truth commission in Australia. So I'll just give a little bit of background about processes in Australia to begin with. British invasion and colonisation had tremendous consequences for Aboriginal and Torres Strait Islander peoples. A combination of warfare, forced resettlements and introduced diseases resulted in the population falling by about 90% between 1788 and 1900. So part of the things that are quite interesting about the founding of Australia compared to North America is that it occurred relatively late. So in 1788 was when the first British colony was set up. And at this stage, obviously, ideas about race were becoming more central to European ideas and European conceptions. And interestingly as well, I guess the colonisation of Australia started as a penal colony. And so people there with guns came there from the beginning. There wasn't really any trade relationship. It started as a penal colony. And so already the dynamics or the power dynamics were quite different from when Europeans first arrived in North America. The next slide will be a bit confronting, but I guess it's nothing that we're unaware of. Following Federation in 1901, law and policy did not just discriminate against Aboriginal and Torres Strait Islander peoples, but it actively excluded them from the constitutional community. They were considered a dying race, Section 51(26) of the Constitution gave the Commonwealth the power to enact laws based on people's race, except for Aboriginal and Torres Strait Islander peoples. So the Commonwealth didn't have any power to deal with or to make laws for the benefit of Aboriginal and Torres Strait Islander peoples. It was left to the states to do that, and they could do it how they wished. Section 127 of the Constitution actually said that when determining the census of the Australian population, you wouldn't count the Aboriginal and Torres Strait Islander people. So that were the only references to Aboriginal and Torres Strait Islander people in the Constitution, and they were both negative or both exclusionary. So they were denied the right to vote, let alone social services and welfare, and many Aboriginal people were confined to reserves or stolen from their families and communities and placed in institutions. Even though formal legal equality has now been achieved and the racist provisions of the Constitution have been expunged, the effects of colonisation, the loss of land and culture continue to reverberate today. Australia has long struggled, or perhaps, as Sir Hilary would suggest, has actively tried not to struggle to come to terms with this foundational injustice. In the last decade, bipartisan political support has coalesced around the idea of recognising Aboriginal and Torres Strait Islander people in the Constitution, providing some explicit acknowledgement that Aboriginal and Torres Strait Islander peoples were there first. And yet, despite 5 processes over 10 years and many recommendations, no government has committed to a specific set of proposals. Once again, I guess, as we'd all know, it's easier for governments to commit aspirationally to change than to actually implement change. Nevertheless, the most recent process, I suggest, might suggest a change, that there might be some positive change. So between December 2016 and May 2017, a series of 12 meetings of Aboriginal and Torres Strait Islander people were held across Australia. Organised by the Referendum Council, a body of prominent Indigenous and non-Indigenous Australians established by the government, these meetings were aimed at hearing what Aboriginal and Torres Strait Islander people thought of constitutional recognition. This was important, not just because the to be recognised should be heard in any discussion. It was important because the previous 3 processes did not specifically ask Indigenous peoples what they wanted. Rather, it asked for the views of all Australians. As a 3% minority in the population of Australia, the aspirations of Indigenous peoples would not be afforded the priority that they deserved in these other processes. So this is quite important because it was the first time that Aboriginal people were asked specifically what they wanted. And the dialogues, as I was saying, were designed in part by my colleague. It's important because, as you'll see in the Uluru Statement, the aspirations that came out of this statement, out of this dialogue process, were vastly different to what the previous 3 government processes had suggested Aboriginal people might want. Attendance at each of the dialogues was by invitation, and meetings were capped at 100 participants to promote discussion. These were inclusive forums. 60% of places were reserved for traditional owner groups, 20% for community organisations, and 20% for key individuals from the community. A balance was also sought between gender and across age groups, and while stolen generations were also represented. The Referendum Council worked in partnership with the host organisation at each location to ensure the local community was also adequately represented in the process. And the dialogues weren't just consultation processes that governments might organise. They were conducted as a deliberative forum. Each took place over 3 days and included opportunities for large and small group discussions. The Referendum Council assisted delegates providing information on the Constitution and the history of constitutional reform. This allowed delegates to discuss and assess different reform options in an informed manner and to explain what recognition would mean for them and for their communities. At the end of the 3 days, delegates confirmed a statement of their discussion and selected 10 representatives for a final convention. So culminating in a First Nations convention at Uluru, delegates from all points of the southern sky, as they described it, called for structural reform of the Australian state to, and I quote, empower our people and take a rightful place in our country. In what has been characterised as voice, treaty and truth, the statement called for constitutional amendment to enshrine a national representative body with the power to advise Parliament on laws and policies that affect Indigenous peoples. So this is the First Nations voice, which is the fourth last paragraph in the statement. And it also called for a legislated Makarrata Commission to supervise a process of agreement making between governments and First Nations, so treaties. So again, a distinction between Australia versus Canada, New Zealand, the United States, all other Commonwealth countries, with that no treaties were signed between the European powers and the Aboriginal and Torres Strait Islander people at first contact, and there have been no treaties that have ever been signed. So part of the deal here was to call for a Makarrata Commission to supervise the process of treaty making, as well as undertake a public truth-telling process. Makarrata is a Yolngu word. They're people from northeast Arnhem Land in the top end in Australia, and it means a coming together after a struggle. And the delegates explained that it captures our aspirations for a fair and truthful relationship with the people of Australia. So these 3 proposals, voice, treaty and truth, are important. They reflect widespread consensus among Aboriginal and Torres Strait Islander people and are consistent with generations of advocacy. In this talk, I'm going to focus on truth-telling, but I'm happy to answer questions about the other two elements of the process or the proposal as well. So here's the Uluru Statement here. Truth-telling about Australia's colonial past emerged as a central plank of the Uluru Statement because the deliberative dialogues revealed that truth was a key aspiration throughout the country. In Brisbane, for example, participants explained that meaningful change to the political legal structure of the state is predicated on the need for Australian society to work on itself and to know the truth of its own history. Similarly, in Adelaide, delegates agreed that we want the history of Aboriginal people taught in schools, including the truth about murders and the theft of land, Maralinga, which is where nuclear weapons were tested on Aboriginal land, and the stolen generations, as well as the story of all the Aboriginal fighters for reform. Healing can only begin when this true history is taught. Here are a couple other statements from the Referendum Council process, the Uluru Dialogues process. So again, part of the focus here with truth-telling is on the non-Indigenous people of Australia, that myself included, need to sort out that history. And it can't just be Aboriginal and Torres Strait Islander people who have to do this work. Non-Indigenous peoples have to work on their history as well, or primarily. So transitional justice scholars have long argued that truth is a precondition to meaningful or genuine reconciliation. And we've heard again and again, I think yesterday and today, how important truth is. As Pat Anderson, an Aboriginal woman who served on the Referendum Council, noted, you cannot make a lasting and effective agreement unless you have a shared truthful understanding of the nature of the dispute, of the history, of how we got to where we are. In their institutional or structural capacity, truth commissions can play a significant role here. They don't simply provide private space for truth to be told, but, as Deborah Yasher explains, provide a publicly sanctioned space for people to speak and be heard. In a context where Indigenous peoples have been portrayed in national discourse as relics of the past, perhaps even as obstacles to modernisation, a Truth Commission can provide a forum for giving testimony in a formal setting that has national and international recognition and support. Or, as Rihanna Chanapin and Richard Vernon put it, Truth Commissions are not only valuable because of what they bring to light, but because they represent publicly the value of truth long denied by the state. A Truth Commission may be a valuable instrument towards meaningful reconciliation in Australia, but care needs to be taken in its structure. The traditional Truth Commission model is designed for states transitioning from recent atrocity, rather than settler states dealing with foundational injustice. Indeed, even the Canadian Truth and Reconciliation Commission on Indian residential schools focused on recent harms, rather than the harms caused by invasion and colonisation. For a Makarrata Commission to help redress abuses suffered by Aboriginal and Torres Strait Islander peoples, and for non-Indigenous Australians to take responsibility for that history, to work on itself, it will need to be designed differently. I think there are three elements of the paradigmatic Truth Commission that are particularly problematic. First, in seeking to reconcile a divided or conflicted society, Truth Commissions naturally tend towards affirming or reaffirming state unity. There's nothing inherently wrong with this approach. All stable and functioning societies require some common bonds of solidarity that prevent the political community from falling into civil strife. The challenge is how unity and reconciliation are conceived. Where these concepts are understood in an exclusionary manner that dismisses Indigenous sovereignty or peoplehood in favour of a unitary notion of identity, it may cause considerable tensions. Unfortunately, this form of a state-centric reconciliation is often a central element of transitional justice processes and truth commissions, which, as Courtney Young explains, are generally aimed at asserting or inscribing a common, singular national identity, and are therefore inherently problematic for Indigenous communities. Indeed, as Ono Bakano notes, truth commissions are almost always incapable of responding to the demands of those disconnected in some way from the state, because their scope, limited to the nation both as object and audience, prevents them from advocating a multinational political project. These structural problems suggest that a Makarrata Commission could face serious challenges for the Australian state has already proved reluctant to meaningfully acknowledge Indigenous sovereignty or peoplehood. While the state does acknowledge the distinct status of Aboriginal and Torres Strait Islander peoples in several ways, dominant understandings of Australian identity continue to marginalise Indigenous peoplehood in favour of what my colleague Mevan Davis calls the sameness that is at the core of national identity. Most recently, Prime Minister Malcolm Turnbull drew on exclusionary concepts of Australian identity to reject the Referendum Council's recommendations and to reject the Uluru Statement. Turnbull explained that such a body, First Nations voice, would be inconsistent with the foundation of Australian democracy and undermine the universal principles of unity, equality and one person, one vote. Quite apart from the inaccuracies of the statement, the proposed voice to Parliament would merely be an advisory rather than a decision-making body. It reveals his exclusionary view of democracy, unity and equality that dismisses Indigenous peoplehood. Conflation of reconciliation with assimilation and group erasure is a central feature of Australian state approaches to Indigenous affairs. Turnbull's statement drew heavily on this settler state pathology, reiterating his government's desire to develop an amendment proposal that will unite our nation rather than establish a new national representative body open only to some Australians. I think Australian democracy is broader than this, though. I think it's broad enough to encompass multiple forms of identity and belonging. Indeed, Aboriginal and Torres Strait Islander peoples have long articulated their relationship with and to the Australian state as one of shared allegiances. As you can see in the Uluru Statement, structural reform to empower Indigenous peoples is desired to ensure that their ancient sovereignty can shine through as a fuller expression of Australia's nationhood. Any process of truth-telling in Australia will not only need to resolve the problems inherent to truth commissions, but will also need to proactively respond to dominant Australian conceptions of identity. As a corollary to their state legitimising functions, truth commissions are often explicitly designed to construct a liminal moment separating past injustices from contemporary just relations. This is something that Sir Hilary spoke about a bit as well, talking about the idea that Western states or European states try to deny and as this denial strategy to pretend or to hope that things pass. Such practice, however, elides continuities of violence and abuse, either in the forms of ongoing physical harms or psychological and societal attitudes that ignore or minimise foundational injustices. This is a common approach to transitional justice mechanisms more generally. Rosemary Nagy has noted that following the intervention in Iraq and Afghanistan, the United States set up a series of transitional justice processes that exclusively focused on rights violations committed by Saddam Hussein and the Taliban. While clearly necessary, this focus artificially demarcated injustices experienced by ordinary civilians, entirely ignoring harm suffered during the now of occupation, insurgency and war on terror. Australian governments have employed similar tactics. Former Prime Minister John Howard's persistent refusal to apologise on behalf of the state for the stolen generations was premised on his belief that present generations of Australians cannot be held accountable, and we should not seek to hold them accountable for the errors and misdeeds of earlier generations. Statements like Howard's and the structural choices of those in Iraq and Afghanistan reveal a political strategy aimed at robbing truth-telling of its moral and political force. If injustices are merely historic or abuses long past, then such harms are either a thing of the past or we may now have to respond to additional and alternative pressing justice demands, and so we shouldn't focus on them. Consequently, meaningful restitution or reparations are neither necessary nor desirable. Rather, in what Andrew Rigby labels cheap reconciliation, restitution is understood as only encompassing symbolic, hollow or performative acts that are never intended to transform relationships. The urge to delimit the abuses to be uncovered by any truth commission exists in all states contemplating such mechanisms, but is particularly problematic for Indigenous peoples, where the consequences of invasion and colonisation persist under changing operational modalities. As the dialogue process revealed, the stories need to be told. The stories of invasion, massacres, resistance and the protection period need to be told. And though these events took place in the past, their effects have not passed. For Aboriginal and Torres Strait Islander peoples then, a Makarrata Commission is not intended to simply flesh out counter-narratives and provide a richer understanding of Australia's past, that is one outcome. Rather, the process of truth-telling is, like Courtney Ewing explains, a bridge intended to draw history into the present. Finally, connected to this is a third issue relating to the scope of truth commissions. Typically, truth commissions focus on personal or individual human rights violations rather than larger structural violence. This emphasis reflects a pragmatic consideration. Though the predecessor regime has lost political power, it may still hold considerable support within the community at large. Anxious to consolidate its authority, the new government will understandably choose to focus on those elements of the past that do not threaten the ongoing viability of the state. This approach was most famously adopted by the South African Truth and Reconciliation Commission, whose mandate precluded the Commission from examining everyday harms and structural injustices perpetuated by apartheid. While the subject of scathing criticism, it's not at all clear that a broader mandate that examined apartheid and its proponents would have been politically feasible at the time. Concern that a Makarrata Commission that examined the structural nature of colonisation could lead to political strife are much diminished in Australia, where there is no risk that a process of local and regional truth-telling could realistically lead to an armed uprising against the state. This fact suggests that there's little danger in the state permitting a Truth Commission to examine a broad range of injustices, beginning with the invasion that resulted in the violation of collective rights that have affected Aboriginal and Torres Strait Islander communal life and their identity. Indeed, as the regional dialogues demonstrated, Aboriginal and Torres Strait Islander peoples see little distinction between individual acts of violence, such as massacres, and the broader structural forces that shape law, policy and attitudes that gave rise and encouraged that violence. Nonetheless, while a broad mandate would not risk the security of the state, it would challenge dominant narratives. The scope of all transitional justice processes, including truth commissions, are highly politicised, as they are sites of contestation over material and symbolic resources. Those who feel challenged by the political consequences of a more fulsome history of Australia's past will push back. As the recent furor over statues in Australia and in the United States, over honouring individuals directly implicated in massacres and racism, indicates, those forces remain powerful and could threaten the viability of a Reparations Commission, or they could agitate to weaken Indigenous rights in Parliament. This is always an ongoing concern for a population that only constitutes 3% of the state. Thanks. I'll just conclude with the last minute then. So the Uluru Statement from the Heart is an important document. Its call for a process of local and regional truth-telling presents an opportunity for lasting and meaningful reconciliation between Indigenous and non-Indigenous persons in Australia. In light of the potential difficulties with existing models of truth commissions, the design of a Reparations Commission takes on added significance. A commission that does not meet Aboriginal and Torres Strait Islander people's expectations and aspirations will fail in its aims and will ultimately fail to progress reconciliation. The problems with the state-focused truth commissions suggest 2 points for an inclusive truth-telling process. First, Indigenous people should lead the process of structural design rather than allow the state to take control of the process, which it will want to do. Second, the Reparations Commission should aim at transforming the existing relationship between Aboriginal and Torres Strait Islander people in the state. In other words, it should aspire to a thick form of redress. So I know we've discussed reconciliation, I've mentioned a bit today. Of course, I mean that in a more structural and thicker form rather than the way that's often meant by the state. This can be approached in several ways, but it should include traditional transitional justice redress measures like education and memorialisation, which are designed to change social and cultural attitudes. But it should also include more substantive forms of redress, whatever they might include. Whatever they might include should be determined by Aboriginal people. Finally, just in the last second, I guess, will this happen? It's not clear yet whether a Reparations Commission will be established, but I'm cautiously optimistic. The current government rejected offhand the proposal for a First Nations voice, but indicated that it may consider a truth-telling process. It's been 9 months since then and nothing appears to be happening, so that doesn't look so likely. But the opposition has committed to all proposals in the Uluru Statement and looks like we'll win the next election. And one of the reasons why Megan couldn't be here today is because she's continuing the focus on the Uluru Statement in communities across Australia. So it's really still being driven by Indigenous peoples. And one thing you'll notice, just looking at the statement, is that it's not addressed to politicians or government, it's addressed to the people of Australia. And so that really is the focus about trying to build a lasting structural reform in Australia. Thank you.
Thank you for this occasion, Robert. I'm Ken Yoshida from Hokkaido University, Japan, located up north in Japan. I'm in civil law that covers contracts towards property. I'm a jack of all trades, and I'm working on disaster law, such as Fukushima TEPCO radiation explosion, or the housing, or environment, or some other issue. But for the last 2 decades, I'm working on reparations in the East Asian context, dealing with concrete issues such as slave laborers, Chinese, Korean slave laborers in Japan, especially in Hokkaido, or the Nanshi massacre, Chongqing bombing, or biological war. By learning theoretical debates about reparations when I was at Harvard in early 2000s. But today I'm going to talk about the Ainu reparation. Ainu people, the indigenous people, especially in Hokkaido. There are about 20,000 people in Hokkaido and 50,000 in total. But actually, there are much more because there are still many people who don't want to identify themselves as Ainu due to the long-term oppression and long-term discrimination in Japan. Japan is one of the developed nations, but regarding reparations, we are far behind the goal of reconciliation. especially the Ainu reparations. Many people might have an impression of a Japanese society. Japan is a monolithic, but the flip side of the coin, the racial minority is very much oppressed, marginalized due to long-term assimilation policy that still exists. Okay, let's start. So this is the chart about terminology. I'm going to use the term reparation as the broader, inclusive term of redress and remedies for the past injustice. Many lawyers still tend to think that the monetary compensation is the only remedies for the past injustice, but it's false. According to the recent research, reparations is much broader. It includes sincere apology, first of all, and second, historical education about past injustice, and third, it's memorial and museum describing human rights infringement. And regarding reconciliation, I think that's a term of getting the antagonistic relationship back to normal by changing vicious cycle of hatreds, as Martha Minow discussed in the early 2000s. And today's presentation, I'm talking about the repatriation, that's returning stolen ancestral remains or cultural artifacts as a part of reparations. And actually, I prepared more than 100 slides, but due to time limitation, I made a short version of slides. But still, I'm going to show you many pictures. So thank you for staying Sunday afternoon. So please get relaxed and enjoy looking at pictures. Okay. And I already okay. And and I had a meeting last month in Sweden with many Sami people, indigenous people there, and they asked me, how come you're working on Ainu reparations? I'm outsider. I'm originally from mainland Japan. Because I'm talking of Japanese legal scholarship, especially civil law scholarship, we are exceptionally heavily influenced by the American legal realism movement in the East Asia. So from my first chance to study abroad in the United States, I got interested in working on critical theories as a ramification of the American legal realism movement, especially critical legal theory and critical race theory, and recently the LGBT theories as well. And I'm going to apply, as I just mentioned, the critical race theory to the East Asian context after making a detour. And this is a picture when I organized the International Indigenous Conference at my campus with many Sami people last December. And this is here is the organizer is Al Brophy, and Jeju is good reparation cases in East Asia. More than 30,000 people have been killed in the late 1940s under the control of U.S. Army. And according to the great contribution of Eric Yamamoto, the English version of a tooth finding report was translated in 2013. And annually, we hold an international conference about Jeju mass killing at various places. And last year, It was held in North Carolina Law School. And here is the chart of theoretical framework of reparations. And there are 4 stages. First, fact-finding by perpetrator side. And second, admission of past injustice and historical responsibility from the perpetrator side. And then, as third stage, sincere apology and supplementary reparations. And last, in some cases, the forgiveness was given by the victim's side. And notice that the latter stage is presupposed by the former stage. Okay, and as many of you know, there's a Comfort Women Agreement in the end of 2015, and according to the agreement, the final and irreversible forgiveness from top down across the heads of the Comfort Women themselves was made. But looking at this chart, I doubt many people understand this process of reconciliation. Because in the diet, the Japanese diet in 2006, the Prime Minister Abe denies the forcibleness in recruiting Comfort Women. But did they participate voluntarily like prostitutes? So the Prime Minister Abe's statement in the Japanese diet infringes the feelings of Comfort Women, as you may gather. And as you know, the accusation decision was made in 2007 in the United States based on the Mike Honda's proposal. So through this theoretical framework, you can easily understand how badly and poorly Japan has been proceeding towards real conciliation. For example, as I just explained, in the Comfort Women issue, the Abe and other cabinet members denied the facts of coerciveness in the Japanese diet. And even the existence of the notorious institution itself, in spite of the numerous testimonies by Comfort Women. And against this backdrop, you can imagine how empty Abe's expression of apology to George Bush shortly before the accusation decision was made in 2007 sounded to the victims. Furthermore, in other cases, such as a bombings case, Japanese government officials have been trying to avoid dealing with factual issues by attacking only the legal discourse. And you can reasonably understand why the leader of Hanaoka litigation, this is the Chinese slave labor case leader. I met with the leader, Mr. Genshin. He was upset by the defendant's attitude to deny its responsibility, even though it agreed to pay 0.5 billion yen settlement money in 2000. And his lawyers proceeded towards a damage-oriented solution. As I mentioned, many lawyers, many legal scholars still overwhelmed by the monetary damages centrism. And why many Korean Comfort Women rejected the proposal made by the Asian Women Fund Agreement in 2000 and by the 2015 Japan-Korea Comfort Women Agreement with 1 billion yen provision, when a sincere apology with the admission of legal responsibility was lacking. So let's get back to the Ainu issues. There is pictures of Ainu people in those days. So Ainu people are nomadic people in northern territories, and I explained their population. But after the Meiji Restoration, the original occupation, that is the fishing and hunting in the coast area or the riverside, was prohibited. Their indigenous coastal land title was denied. So Ainu Moshiris, that's the Hokkaido by their language, was conquered by terra nullius doctrine. And mountainous area, mountainous, barren, and hilly tracts of land were allotted by the 1899 Hokkaido Formal Native Statute under the strict condition that it should be cultivated within 15 years. So here's the picture. The minute this on your left-hand side, that's the hilly, almost cliffy area, allotted land, and the 1899 statute modeled on Dawes Act in the United States, very discriminatory statute. And many Ainu people were unsuccessful, and they lost everything. And there are many cases of displacement. And furthermore, the Japanese and Hokkaido government and their hired scholars, including Hokkaido University Indigenous Research Center, it's deceptive for foreigners. It still rejects a reparations approach mandated by the United Nations Declaration on Rights of Indigenous Peoples in 2007. So they used to have lots of communal property, but the property neglected. Repatriation of more than 1,000 stolen ancestral remains denied, unlike the practice in Nagpra in the United States in 1990. The education of the past injustice still evaded by the government on purpose. The enlarged museum will be open in 2020 when the Tokyo Olympic Games will be held, but without any exhibits of their past injustice, unlike Holocaust Museum or African American Museum in the DC. There are policies set up by the Japanese government officials from top down across their heads. There's no, it doesn't exist the right of self-determination. That's the core right of the UN Declaration. And their sacred places have been submerged by the construction of Nibutani dams and so on. This is the picture of Nibutani Dam that's located in the central area, or the southern central area in Hokkaido. And some other similar dam is now being constructed that will submerge other sacred places of Ainu people. So if you look at the reparation cases regarding the indigenous people outside of Japan, such as the post-apartheid situation in South Africa or Native Hawaiian reparation problems in the US, they are moving in the right direction. The South African Truth and Reconciliation Commission took an amnesty approach, but put emphasis on telling the truth about past injustice by perpetrators, and on repentance at the level of their conscience in order to attain reconciliation, following the African philosophy of Ubuntu, or community-oriented sense of comradeship and restorative justice opposed to retributive justice. But as for Ainu, by using my theoretical framework, the Commission report in 2009 seemed to pass the first and second stages, but strangely enough, it rejected the following stages. Come to think of their inconsistent policymaking, now I doubt they really took Japanese past injustice towards them seriously, and that they really understand the historical responsibility in its true sense. So this is the picture of our campus. Hokkaido University is the one of the most spacious and one of the most beautiful campus in Japan. But very few people know that the campus used to be the Ainu village And the university was established after the conquest of Ainu people there. There's a still negative legacy of colonialism in our university. And unlike the roles of University of West Indies, the still Hokkaido University plays a negative role of our university. We have to think about what happens if the director of Hokkaido Ainu Indigenous Center is hired by the Japanese and Hokkaido government who still want to manipulate Ainu people by denying the UN Declaration, core rights of indigenous self-determination, group rights, and communal indigenous notion of property. And there's a beautiful river named Sakushu Kotoni running in the central lawn of Hokkaido campus, in the campus. But nobody knows, very few people knows that Kotoni comes from the name of Ainu family conquered there. And there's no description of the conquest of Ainu land and the recent repatriation of Kotoni villages in the sign near the stream. And there's the international repatriation of Ainu ancestral remains regarding the Ainu village, Kotoni Ainu village in my campus. After more than 100 years, 138 years ago, the German traveler stole the Ainu remains from the Ainu tombs in this village with the aid of the scholar hired by the Hokkaido government. But after so many years, the German Association of Anthropology, Ethnology, and Prehistoric Geography started their repatriation because they thought the stolen remains were identified. But look at this picture. This, left-hand side, this is the top leader of government officials. The remains, the skull of the famous Ainu leader of the village is given from the president of the German Association to the top leader. And actually, I met with a previous president in Berlin Freie Universität last summer. He admitted the past injustice and historical responsibility regarding the long-term possession of stolen Ainu remains for more than 100 years, and criticized the president's approach if he did not make a sincere apology at the ceremony. And after returning, the skull was kept in this repository room. There are more than 1,000 stolen ancestral remains in the repository house, and there's an annual ritual by the Ainu people at the beginning of August. But I found the descendant of the victims, the remains. But the ceremony was held across her head. She was not notified about any event. That's the case, typical case. And we went to their ancestors' grave, but the bones are missing. You know, almost all bones, if you go to every Ainu tombs, almost all the Ainu ancestral remains were stolen by the Hokkaido University professors. So she wants to keep her ancestral remains at her grave. However, Hokkaido University rejected the repatriation by mentioning the individualistic notion of property. So I'm still in the middle, so. And from the last part of my presentation, I'm going to mention some taxonomy of reparations first. In this slide, regarding legal reparations, there are lots of hurdles, such as passing of time, lack of evidence, and legal principle related to passing of time, prescription, limitation of action. And third, the state immunity doctrine. Fourth, the waiver clause in international treaties. And the legal reparations are partial. We have to realize the legal reparations are partial and sometimes contingent on many accidental factors. And so legal reparations are not a panacea for the past tragedies. And from the next slide, I mentioned a couple of taxonomy of reparations. The first, moral reparations and the legal reparation. Moral reparation is the base of legal reparations, and it is mentioned by Rob Brooks, and yesterday, Professor Chisholm also mentioned a similar thing. And this is a chart of a contrast of legal reparations and moral reparations. Legal protection is partial, whereas moral responsibility is more holistic and basic. Legal responsibility is more official. Legal reparation can be coerced, whereas moral reparations are performed voluntarily. In this sense, the former could be performed without sincere regret, while the latter presuppose a moral reflection, remorse, thus they are more foundational. And second taxonomy is, as many of you already discussed, the symbolic reparations and economic reparation. And I'm going to skip. This taxonomy is made by John Toppy, Professor Toppy, for example, and this is a picture taken several years ago. And the third, group reparations, this is the end. The group reparations and individual reparation. Professor Robert Wesley argued the merits of group reparations and trust funds in slavery case to avoid the difficulties of individual reparations, such as identification of victims and reverse discrimination. The same thing can be mentioned about indigenous people's reparation, and group reparations should be recommended for them. Although I know policymakers taking on purpose a negative position on reparation by taking recourse to individualistic argument. A group reparations approach is useful for Ainu reparations in the case of their repatriation and environmental injustice. So this is a picture last year. And so in the face of this situation, we established a Citizens Alliance with many Ainu people, and we plan to make a counter proposal and submit it to the United Nations Human Rights Council in the near future. So we need international collaboration on these issues. Thank you.
Okay. I too wanted, are we ready? Yeah. Okay, great, thanks. I too wanted to say thank you for the opportunity to be here. It's an honor to participate and to speak with all of you. I want to say thank you to the sponsors and all the organizers, to Robert and Saru and Jake and Andrea and everyone else who put a lot of effort into this gathering. Like Harry, I feel like wherever we are, we need to be grounded very literally. We need to pay attention to the ground on which we stand and sit. And acknowledge that we're on what I believe is Chirimacha and possibly Homa lands. It's one of the problems here is that, given the nature of settler colonial devastation, it's sometimes difficult to know whose lands we're on. And I also think that we need to acknowledge that we are in fact in a settler colonial state, one whose very existence depends on the genocidal appropriation of indigenous lands, and whose wealth and power was extracted from and depended upon the labor of enslaved peoples indigenous to this land and Africa. This is a panel discussing indigeneity. I don't think that the issues of indigeneity are as distinct from those of African slavery as we often presume them to be. This is true for a lot of reasons, many of which were referenced by Sir Hilary in terms of the similarities and the parallels between the treatment of peoples. But it goes even deeper than parallels, right? Because we're talking about indigenous African peoples who were stolen, transported to another country. We're talking about the often enslaved African peoples who joined up with indigenous peoples and were incorporated into their societies. We're talking about indigenous peoples in the Americas, millions of whom were enslaved by the British and others, who were, for example, many from New England were taken and enslaved, and the men were sent to the West Indies, and the women were sent to plantations in the Southeast. So we have very literally, we're talking about the same people. And I think we need to really sort of start to look at some of the levels of interaction there. A lot of what we've been talking about here has come back around to the questions of equality and participation in a unified society. And that's a difficult concept, or at least it's difficult for me to stop there when we're talking about settler societies, at least. I, of course, presume that we are all entitled to equality. I'm certainly not saying that's not an important aspect of what we're struggling for, but I don't consider to be being treated equally as being redress for any past wrongs. And I'm concerned in the context of a settler state that is still here, this is still a colonial occupation, that when we talk about equality for any of us, we're talking about an equal division of the spoils of colonization. And that's not okay. At least it's not okay with me to claim to be an equal part of the colonial occupation. And so there's two problems with that, sort of, if we stop at an equality framework. One is that, do we just want to be colonizers too? In which case, if that's your goal, fine, but I'm not interested in talking about it. Well, the other problem is that I believe that to be a futile quest for people of color in this country, for reasons that I'm sure you're all familiar with and are too complicated to really go into here, but it has to do with what Anthony Angie has described as the dynamic of difference that is essential to colonialism. You can't have continued colonial processes and structures without a dynamic of difference. And therefore, for us to think that we're going to have a kinder, gentler, non-racist colonialism is just fantasy land. I think we need to be looking beyond that to what it means to be actually liberated, actually decolonized, and what it means to have self-determination. We've talked about a lot of different kinds of reparations, a lot of dimensions of reparations, and I think it would be helpful in our discussions if we could find ways of sort of parsing out some of the different types, right? We have sort of state-to-state types of reparations. We have reparations from states, because that's mostly what we've been talking about, to particular individuals or groups that could, at least in theory, be given without threatening the nature of the state itself. And then we have situations in which we are looking for reparations or redress from states for foundational wrongs, for wrongs without which the state could not have and could not still continue to exist in its present form. And that raises a whole host of much more complicated problems that I think we've been addressing in this panel and in many respects throughout this conference. And I would just want to talk a little bit about those. Before I do that, I just wanted to say that my benchmark in looking at redress, this is just my personal benchmark, is as we struggle for these things, because we know we're looking at big picture solutions, and yet we can only engage in very specific, concrete actions. And so it's hard to know what is a positive thing and what is not. My family, on my father's side, was interned during World War II, and my father was a beneficiary, if you will, of the redress for the Japanese American internment. And in the course of looking at that, I had a lot of issues with that whole process. But I had to recognize that it was extremely important to have that history acknowledged, to have the government, to have official recognition that a wrong was done, that made a huge difference psychologically to individuals and to the community. But we also have to recognize that in that case, as Chris Ijima pointed out so poignantly, that redress or reparations can take a form which actually reinforces the underlying harm. And in the Japanese American case, an example of that is that bill passed Congress because of all these arguments about how loyal we were, right? We were so loyal. We went along with the program. We volunteered out of internment camps, concentration camps, as Roosevelt himself called them, to go fight in Europe, right? So we were not being given redress for an acknowledged wrong, even though they kind of pretended like they said that. We were given redress for going along with, for helping to facilitate a wrong, right? The people who really resisted were not the heroes there. The people who cooperated it were. And in that sense, we were framed as the model minority, right? We were the ones who other minorities were supposed to emulate. So there's a lot of really dangerous potential in redress and reparations and how they're framed and what we do with them. That doesn't mean we don't struggle for them. And that doesn't mean as Japanese Americans we didn't need to try to get those harms acknowledged. But we have to be very careful not to be used in whatever form we take. So my sort of litmus test as I look at struggles and movements for reparations are which measures or struggles are empowering to our communities and potentially liberating, and which are in fact ultimately reinforcing our own subordination. I have a few basic sort of themes I'd like to point out. One is that I think sort of run through a lot of the discussion we've been having. One is the basic, some call it the most basic human principle of our human right of dignity, right? We have to struggle to have our realities acknowledged, to call out these historic injustices, to invoke law in the service of justice, to fulfill our responsibilities to future generations. We have to do that for our own sakes. It doesn't matter what we're going to get or not, right? That's part of our maintaining our dignity and the dignity of all peoples. The second has to do with acknowledging power and the power dynamics at issue. We can't cede power as we do this to those who perpetrate injustices, and therefore I don't think we can ask for or frame our demands in terms of charity or development or aids or grants. Those might be necessary and they might help us survive, and we might be happy to take them when we need to, but they're not going to liberate us, right? We have to recognize and build on the power that lies within our communities at the bottom, at the grassroots. And then finally, my main focus here is a theme that we've been discussing throughout this conference of truth, right? But here I'm talking about truth, our acknowledging truth as we frame our struggles for redress and reparations. I'm not so much talking about getting the perpetrator's society to acknowledge the truth, although obviously that's necessary. We can't build a liberated future on lies about the present or the past. And to me, that means acknowledging that the contemporary statist world order was built on colonial occupation and enslavement. That order was not, I believe, truly decolonized in the 1960s, the so-called decolonization era. I think it was basically simply expanded as former colonies were recognized as independent states. And certainly settler states were not decolonized, right? So my primary point today is that as we look at settler states in the United States in particular anyway, who owe their very existence, their claims to the territory, to the wealth, to the power they have, and the control they exercise over populations, all of this is owed to these foundational wrongs. Even our very notion of property, right, as has been sort of acknowledged at some point, property itself, the land, how the land is conceptualized, how people are conceptualized, has been racially defined, right? There's so much here we have to unpack, right, that goes beyond redistributing some of that property. And my real primary point that is not a real comfortable one, but I can't see any way around it, is that such foundational wrongs, I don't think, can be remediated unless we are willing to question the legitimacy of the state itself and its claims to sovereignty over lands and peoples. And I want to say, this does not mean that I am advocating a tax on state structures. I am not saying that there can be no justice until some magical point in the future when states disappear. I am not arguing against efforts to obtain redress from states through executive action or legislation or judicial decisions. However, I am saying that we cannot start from the premise that state formations as they currently exist are right, natural, inevitable, or inviolable. If we're not willing to think more creatively outside of the box, there's no point in struggling to redress foundational wrongs. We can redress more limited wrongs, but we can't address foundational wrongs. There's nothing magical about these universal and exclusive definitions of state territorial integrity or power, as I think was brought out in your presentation and in Caleb's yesterday about Canadian sovereignty. I'm also saying that international law can be very useful in advocating for reparations, and that seems like a contradiction because international law arises from and is dependent upon the agreement and/or consent of states. But that's actually why I think it can be useful. Domestic courts are almost never going to acknowledge, much less remedy for wrongdoing by the states of which they are a part, as Chief Justice John Marshall so candidly acknowledged in Johnson versus McIntosh, when he said, this might not really comport with what anybody thinks is fair or right, but we are the courts of the conqueror, and we have to play that role, right? In international law, by contrast to domestic law, we have states acknowledging a set of mutually agreed upon rules, developing a system for identifying violations of those rules, and remediating those violations. And people have talked about international law significantly today, so I'm not going to spend a lot of time on it. But I just want to emphasize the fact that, in general, the purpose of remedies in international law is to restore the status quo ante, right? That's a really significant construct as we think about reparations in international law, to restore the things to the state in which they were before the violation took place. That is the goal. Doesn't mean you can always do it, but that's the goal that we start from, and then we work from there, right? States have to provide access to justice and effective remedies, and a failure to provide a remedy required by law constitutes an ongoing violation. Now, these were rules that the states developed, the civilized European states, so-called, right, developed for their interactions with each other. They didn't intend for them to apply to us, but as international law has expanded to recognize non-state actors, including peoples, those rules still apply. They made us, as in the so-called decolonization process, they forced us to acknowledge that their rules still applied and to play by those rules. And they can help us in this case, I think. The basic principles and guidelines that Professor Rao discussed yesterday lay out a very useful framework, right? They talk about reparations. International law, when we talk about reparations, remedies in general are called reparations. Right, that's the big heading. And then under that, we have different types of reparations. We have restitution, we have compensation, rehabilitation, satisfaction, guarantees of non-repetition. The most significant one is restitution, to try to restore things to the way they were. When that is impossible, when that cannot be done, then we look to compensation, right? But we don't start with compensation. We recognize that might not be the thing. And the other point to note is that the perpetrator doesn't get to decide. They don't get to decide what the remedy is or the extent of the remedy. So given this backdrop, I think that we have to sort of free up our minds to apply these principles because they have tremendous potential for the assessment, if not the actualization, of lawful remediation of the foundational crimes attending colonialism, including the ongoing illegal occupation of land and the appropriation of resources, the kidnapping and forced relocations of peoples, their enslavement, and the ongoing harm that results from that, which kind of gets us back to the importance of truth, right? Restoring the status quo ante requires us to think about state claims to this occupied territory, to the right to exploit its natural resources, to its control over peoples. Think about, we talked about equality and citizenship here. Before we go there, I mean, we, obviously, as I said before, I'm not advocating for inequality, but before we just assume that that is the goal, we need to think about, where does this citizenship come from? Right? The 14th Amendment imposed citizenship on people of African descent, and that's great, if they want it, right? They didn't ask for it, right? Citizenship was imposed upon American Indians in varying stages, but primarily in 1924. They didn't ask for it. It was a way of undermining indigenous claims for sovereignty and self-determination. And, we can't just presume that that's the end point. We have to look at the presumptions that go with the settlers' presumed right to control the borders. We have a lot of immigration issues now that rest on accepting that premise. We don't have to accept any of these premises. And we could go into sort of the law and the relevant law that applies now, and we can go into the question of, but wasn't it legal then? And basically, I would say no, and I think Sir Hilary has made a really good argument with respect to slavery about that. But I also want to point out that even if you believe that it was legal then, the only way I think that argument can be legitimately made is to acknowledge that all of these things, slavery, occupation, genocidal measures, were illegal between the European colonial powers. They knew it was illegal to do it to each other. The only caveat they made in their law was it was okay to do it to people who were uncivilized, who were savage, and that was determined on a racialized basis. And so, if you want to hang your hat on the "but it was legal then" argument, you are hanging your hat on they knew it was wrong to do it to each other, but they didn't consider the rest of us people, and therefore said it was legal. And I'm not going there. Y'all can go there if you want to, but I'm not going there. So, in my last minute, I would like to say that I think where this leaves us, obviously there's a lot more that could be said about all this, but as far as I'm concerned, the colonial powers have the ability to cough up a whole lot of much-needed resources, as Sir Hilary was advocating earlier, and lots of folks have advocated throughout this conference, and those are very important. But that will never provide the solution to our problems fundamentally. I think our well-being, our dignity, our balance will only be restored with self-determination. And in so doing, we have to figure out which are the strategies, the lawsuits, the campaigns, the political struggles, the political education campaigns that are empowering, which ones lead us in an empowering directions, and which ones we need to avoid, because even though we might want that immediate gain, they're actually undermining our steps, our ability to be self-determining. I think that we certainly need to do the kind of sorry, I had to turn that off. Go away. All right. I think that we do need to do the kind of hardcore accounting and structural assessment that's been discussed throughout this conference, certainly exemplified by the work of Eric Williams and Walter Rodney. We need to establish the extent of the exploitation and the concomitant benefit that was reaped from it, even if redress for wrongs of this magnitude seem unrealistic, right? We start there. Then we accompany this with public education, with a discussion, an honest discussion about how these wrongs are ongoing and pervasive and how no sector of society can stand apart from them. I think we have to acknowledge the illegitimacy of settler states. And then we start to negotiate, right? all of this does not mean, poof, the settler state goes away. Poof, everybody goes back to wherever their ancestors come from. Nobody's asking for that. Nobody's saying that. But we start from the position that we don't presume the legitimacy of what exists. We start to negotiate from the realities and the truth, and then we see what we can work out. Thank you. No questions, we can go home.
Sorry. First of all, thank you to all the presenters. Learned a lot. One of the things, Natsu, your presentation triggered in me was that reparations is really not the end either. And one of the things that I think even those who call ourselves reparationists, which I do style myself as a reparationist, is actually, we're afraid of that point you just made. That in fact, many presume the legitimacy even though we talk about it as being illegitimate. We presume it because we presume we can't change it, that we can't change that foundation. And so, for me at least, that last statement opened up more because it also helps us look at white supremacy, at least in the U.S. context. White supremacy, part of the harm is to presume that we cannot change that foundation, and therefore we're stuck. So how do we move to your point? How do we move to your point of at least examining the ability to change the legitimacy?
I mean, for me, a lot of it is getting a deep history, right? To look at things from, the perspectives of the histories of a lot of indigenous people that go back millennia, right? This is a blip. It's a horrible blip, but it's a blip, right? We look at the history of Africa, before 400 years ago. We look at all of, the ongoing histories. We look at the world in 1950 versus 1975 and look at the transformations that were made there with respect to states and state formations and the legitimacy of colonialism, external colonialism anyway. And we see that there's always change, right? There have been all these different changes, empires, different kinds of state formations, non-state formations. We can have multiple overlapping. We don't have to have singular identities. We don't have to have singular racial identities. We don't have to have singular ethnic identities. We don't have to have singular national identities. There's all kinds of ways in which we can see different possibilities. And to me, like educating ourselves and our families and our children and whatnot about all of those different perspectives, a multiverse of perspectives, is how we start to free up, as Ngugi wa Thiong'o said, right? We decolonize our minds.
I had a question for Professor Yoshida, but it comes from something Sir Hilary said this morning about the role of universities, because you mentioned even in the sort of the low bar of these are remains, they're on the stolen land that even that was something the university could say no to. And I wonder, we've been talking about the importance of universities playing their role in these conversations, and I wondered if talking about the university versus talking about research and certain kinds of academic expertise, and maybe there's a more productive path for think tank entities that are outside of universities, because universities, they're not like states, but they have their own interests, and getting them to critique themselves. And, I sort of wondered about that conversation, because we are all, in some ways, merely by doing the conference, saying that the university has this role, but I'm wondering if there's some other structures we can imagine in which we can better deploy sort of academic research, in fact, because, as Sir Hilary said, these universities, and as you noted, they, in fact, have played their own role in doing the harm, and we're going back to the person that did the harm and asking them could you please describe your punishment? So maybe there's some other institutional way to use research, sort of seeking our end.
Yeah, as I mentioned, there are so many still systemic problems in Japanese society as well as our universities, and I'm envious of the scholars' positions of University of West Indies, or the research group that is really sympathetic to the racial minority. But in our case, we are divided. My colleague at the same department will be hired and become director of kind of deceptive indigenous research center. But really, he brought the reparations approach. You can't imagine. And I'm outside of the decision-making of the Hokkaido University, such as repatriation, even though this is my field. But some other field scholar decides everything. So there's a collusive relationship between the government and Hokkaido. Still, so in that sense, we still have a negative legacy still existing, and it's sad to say, but we have to change this systemic problems. That's why I organized the Citizens Alliance from the grassroots level, and Ainu people are very happy about our efforts, because they themselves are seriously deceived by again, after the establishment of Ainu Indigenous Center about a decade ago. So successfully they've been deceived. In the several decades ago, they had to help steal the ancestral remains. And in case of the international repatriation case, the Japanese government official blocked the repatriation, as I mentioned, and it's now in the repository house in our campus, and across the heads of the descendants. And after the what is called Ainu symbolic space is being constructed in 2020, and another big repository house will be built, and it's carried to avoid past injustice. So very we are in outdated situation, sorry to say, but we have to change this, and so that's why we are planning to make a counter report and submit it to the United Nations, and so that's why I'm here to get all of your international help and to build the international alliance. And theoretically, it's same. We need they suffered the successive hardship, and they've lost everything. Many of them, majority, the Ainu people live on welfare, and it's paradoxical that after the new statute was made in 1997, after the abolishment of the Hokkaido former natives, the statute was abolished. But paradoxically, due to some budget by the statute, some Ainu, the elite Ainu, have been manipulated by the government, by that budget, so to say. So, is it okay?
Hi, yeah, thank you so much for this talk. I really appreciate that the question of settler colonialism has been so centered, because I think there's a tendency in some of these discussions to reproduce the idea that indigenous peoples do not exist, and I really appreciate that. And especially this idea that the US is an illegitimate settler state. I just wonder, for those of us who work in Western Europe, that argument doesn't often work very well. People don't really listen, they don't really understand. I myself didn't know that much about settler colonialism and how it looked and operated until I moved to this country. So I just wonder how, if you have any advice or how we might open a conversation about how in Western Europe, how do we make the argument that Western European states are also illegitimate, given that they are not technically settler states anymore?
That's a big question. But, I mean, part of the problem there, I think, actually is that there has been a burying of actual European history, right? I mean, it's not like there weren't indigenous peoples in Europe who were buried and overrun and, you know, culturally assimilated out of existence in that sense. And I'm not sure that it is exactly the same thing in terms of I mean, I do think ultimately, historically, it is the same thing, but we might not be able to have the historical evidence at our disposal to make that case. But we certainly can make the case about the nature and existence and boundaries, probably, of these states being dependent upon colonization, right? And that, I think, that's where we bring all the threads together. We show those, and it's not just you know, like, it's not just these people owned slaves. It's the structural, systemic nature of the slave trade, of all the appropriation of natural resources, all the ongoing, continuing, you know, lease agreements that the European powers forced the newly independent African states into to give up their natural resources, blah, 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 right? Their participation in ensuring that friendly regimes, you know, took hold in certain countries, all that kind of thing, right? That enriches the states and allows them to have the form that they are now in, to me, speaks to their illegitimacy. And that's where I'd go with it, but. Did you?
And as Knights mentioned, that I myself think regarding the U.S. Federal Indian law, there's still a negative colonialism legacy to Johnson versus McIntosh, and you still have a discovery doctrine, and same as in Japan. So, for example, in the North Dakota pipeline case, after the governmental change, the Native Americans' situation is very precarious, and I met with last year. I met with the chairman of a Standing Rock Sioux tribe, and he himself is very unsatisfied with the U.S. case law. And
yeah, I think it's a really good question, and I think it comes back to history, as you were saying, sort of burying the history. I've just got two examples, or two sort of points that I want to note on this, and this is just because part of my comparative research for my thesis is on Sweden and the Sami people in Sweden. And there's just sort of two things to talk about, I guess, the way that the state boundaries have been constructed and the sort of the exploitation and you know, dispossession and destruction that was entailed in that. There's a quote that I found, I think it's the 1890s or 1910s, I can't exactly remember where it is, it's around that period. Sweden's resources minister, and he's quoted in a sort of a celebratory speech saying that he wants to turn the north, which is where the Sami people live and still had some sort of quite clear separation from the Swedish society, that he wanted to turn the north into Sweden's India. Which I think is a sort of really telling on a number of levels about how Europeans considered non-European countries, and also the way the Swedish state operated in relation to the Sami people. And that still happens today. There's a Sami representative body, Sami parliament in Sweden, but in 2017 when I was there, they had thankfully just won this case, but the first land rights case that was successful in the Swedish district court, which is their lowest level court, where the Sami village, which is the administrative unit, the way that it's termed in Swedish law, was arguing for rights to hunting and fishing and land in this particular territory. And the Swedish state ran the argument that because they're nomadic people, they don't have any rights to land. And so this is 2017, the Swedish state is running a terra nullius argument. So I think that's something that happens throughout Europe as well. Yeah.
Yeah, and
So I hate to do this, but we're running really over time, so if, I hate to shut, but I'd like to thank our panelists. So, a short 5-minute break, then back at 3 o'clock for our final panel.
Okay. We're going to need to get started with this final panel of the day, the final panel of the conference. I don't know how many folks might have come across this Stoppelsteine, Stumbling Stones in Berlin. We were talking earlier about different ways to memorialize our history. This is a very interesting way that they do it in Berlin. And I think it nicely complements the mapping slavery project that Nancy talked about earlier. On this panel, we have Thomas Kramer, and Thomas is an associate professor at the University of Connecticut's Department of Public Policy. We also have Hans Christian Jasch, and it's not included in the abstract, but Hans is the director of the Wannsee Conference House. I don't know how many people might be familiar with that, but this was the place that the top Nazis went to plan the final solution. It's now a museum. And Hans is being assisted by Catherine Jansen, who is at Humboldt University in Berlin. And we also have Sarah Kiani, who is a senior researcher at the University of Lausanne in Switzerland and at the Center Mark Bloch in Berlin. Okay, let's get started. And I just wanted to say one further thing, actually. Because we're running behind, unfortunately, I don't believe that Thomas is going to be able to stay for the Q&A period, so he's probably going to have to go out and catch his ride to the airport after his presentation.
All right, thank you very much. First, it's not on. Okay, I first want to say thank you very much to Professor Robert Wesley for allowing me to be part of this important event, and to the GAM family for sponsoring it. In my presentation, I'm going to make some references to legal issues. I'm going to talk about history, and I'm throwing a lot of dollar figures at you. Yet I am not a legal scholar, nor am I a historian or an economist, so bear with me and feel free to jump in and correct me wherever I'm making egregious mistakes. My presentation is entitled Comparative History of Holocaust and Transatlantic Slavery Reparations. I should mention that transatlantic slavery is, for me, the abbreviation for the slave trade. The term trade gives it such a legal feeling, and I'm going to challenge that in my presentation, so I'm just going to talk about transatlantic slavery instead of the slave trade. In place of an introduction, let me introduce you to a late friend of mine. His name is Miechu Langer, and he was a survivor of the Holocaust. He survived 5 concentration camps and a death march in his youth. And yet he retired from Israel to Germany in his old age, and this is where I got to meet him. And we went on a spiritual journey to the place where his entire family perished. This is where this picture was taken. And this gave me an opportunity to be able to express to him the shame that I felt for what my people did to him and his family. And in response, he embraced me. And later on, I learned that he had received a reparations pension from the German government since the 1970s. And that signaled to him that Germany was serious in its willingness to change its ways. And it signaled to me that my country was taking responsibility in making amends. So in a psychic way, it had benefits for both of us. And I think this is important in the slavery reparations discussion, that slavery reparations can have benefits for the descendants of perpetrators as well. In my presentation, I will first... Am I in the right? Yeah, I will first talk about the legal context of German Holocaust reparations, then about the legal context of transatlantic slavery reparations, about the political resolution of German Holocaust reparations, and then about some proposals for transatlantic slavery reparations coming out of, mostly out of Africa. And then I'll compare German Holocaust and transatlantic slavery reparations in terms of the orders of magnitudes, whether one is totally disproportionate to the other or if they are comparable. So let me talk about the legal context of German Holocaust reparations. Crimes against humanity, for example, the Holocaust, were not formally defined until the Nuremberg trials of 1945. So this led to a criticism of the Nuremberg trials as the retroactive application of the law, for example, by people like Wyszynski. And in response to these charges, the US prosecutor at the Nuremberg trials, Robert H. Jackson, argued that the judgments at Nuremberg only seem retroactive based on continental law, as he called it, not according to common law. And he said in continental law, rulings are deduced logically from written rules, whereas in common law, they're based on precedent, and written rules evolve inductively over time. And then he stated, unless international law is to be deprived of this common law method of birth and growth, the judges at Nuremberg were fully warranted in reaching a judicial judgment of criminal guilt. And I see a parallel there to slavery reparations. I will later describe that, that Holocaust reparations were not a result of the judgments at Nuremberg, but the legal situation is nonetheless similar, in my view. Transatlantic slavery was internationally outlawed through the International Convention to Suppress the Slave Trade and Slavery as late as 1926. And the idea that it was somehow legal before 1926 seems kind of strange. So the question is, what was its legal status in the 16th century at the dawn of transatlantic slavery? So in my paper, I'm looking at basically all major European powers that were involved in the slave trade and looking at the law at the time. And I found for Britain, France, the Netherlands, and Denmark with its junior partner Norway, and then Sweden with its junior partner Norway, and for the Duchy of Courland, which was part of the Poland-Lithuanian Commonwealth, which introduced slavery in the Gambia region, that in all these places, Roman slavery was considered illegal centuries before the transatlantic slave trade started. In Spain and Portugal, the situation was a bit different. There, the reception of Roman law made it possible for slavery to exist legally, but only as the result of imprisonment of capture in a just war. Which, of course, the kidnapping of Africans and war for capture of slaves was not included. Also in Portugal and Spain, the enslavement of some groups, for example, Native Americans, was considered illegal, whereas the Africans and technically Europeans could be enslaved legally. And finally, in many African states, there were legal forms of serfdom and vassalage, but not chattel slavery. So this is often a misunderstanding that chattel slavery existed in Africa at the time, but according to Nora Whitman, who investigated this in great detail, this was not the case. So in summary, this paints a picture of slavery being definitely not not legal in the international sense, in a common law interpretation, as far as I understand it with my limited knowledge of the law. So technically, a legal case could be made, but I'll point to the German example of how Holocaust reparations came about, that a legal judgment was not even required. And this is due to the fact that representatives of the perpetrator side reached out to the victimized side with an invitation for direct negotiations. This was when West German Chancellor Konrad Adenauer said on November 11th, 1949, "The German people are resolved to make good the wrong done to the Jews in their name. This reparation we regard as our duty." And it's interesting in this context to realize that the reaction in Israel was in no way positive. Many Israelis vigorously opposed the idea of direct negotiations with Germany, which is perfectly understandable. This is a picture of a demonstration with Menachem Begin. The poster reads, "Our honor shall not be sold for money." And despite these protests, basically the two sides got together and hammered out an agreement that included a number of components. The first, in 1952, was the resettlement of 50,000 refugees, and I've put the dollar figures down. I should mention, all the dollar figures in my presentation are in 2016 dollars in order to make them comparable across time. Also included in the 1952 agreement was reparations for heirless estates, and an agreement that Germany would enact open-ended legislation for reparations of, reparations to Holocaust survivors. And in 1988, another push was made for Germany to pay Holocaust survivors, and in 1999, to the last remaining slave laborers. I've tried to look to get as accurate a reading of the amounts as possible. I'm not sure. I think the open-ended amounts in 1976, I got them only up to 1976, so they probably don't reflect the full amount. But roughly, I'm getting to $30 billion overall, and that across 6 million victims is about $5,000 per victim. So not a big number, a rather symbolic amount. It's a conservative estimate, but I want to compare that to the demands of African slavery reparations to see whether they're in line or completely out of proportion. So let me look at proposals for transatlantic slavery reparations coming out of Africa. In this table, I've ordered them in the order of increasing magnitudes. The first is a proposal by the group of eminent persons that devised a Middle Passage plan modeled on the Marshall Plan. They did this in 1992 to the tune of about $122 billion. And this is followed by Babangida's tripartite summit, which recommended debt relief in 1991. And at that time, that would have amounted to $447 billion in 2016 dollars. And then is a proposal by Osabu Klee, who basically recommends that victims of enslavement in Africa should be compensated according to an international convention on the compensation of air crash victims. I calculated the transatlantic portion. Of course, his process involves both trans-Saharan slavery and transatlantic slavery, so I've calculated the transatlantic portion to about $44 trillion. And finally, the Truth Commission conference held in 1999 recommended or demanded $1.14 quadrillion. So that's a huge amount. So this proposal, though, is not limited to transatlantic slavery, but it includes reparations for colonialism, so it covers a large area. But still, the numbers look incredibly large. So this has led to some otherwise sympathetic reparations scholars to call these demands decidedly absurd. I was not sure based on what they were considered absurd, most likely just based on the large amount. So in order to get a baseline for comparison, I was interested in comparing them to Holocaust reparations. And in order to do that, I basically went to the figure of $5,000 per victim in 2016 dollars, and I used Emory University's transatlantic slave trade database and imputed missing cases according to various formulae that I'm not going into detail now in the interest of time. But there are various estimates of victimization through the transatlantic slave trade. The most conservative estimate is from Emory University itself, 12.5 million enslaved Africans that were embarked in African ports in the time frame between 1514 and 1866. But Nora Whitman estimates that for every one enslaved African disembarked in the New World, so that had survived that the Middle Passage, there were 4 deaths either on the transatlantic passage or in the African interior on the way to the coast. That would bring up the total number of victims to 53.51 million. And Osabu Clay has an estimate where he also is interested in looking at victims from the wars that were waged for enslavement and the offspring that these victims never conceived. That's a much larger concept. And he estimates that to 1 billion. Again, that combines trans-Saharan and transatlantic slave trade. So the transatlantic portion, I estimate roughly to 413.79 million victims. This all seems very cold and calculating, but it's important to look at those numbers. Now, in order to come up with estimates that I'm basing on Holocaust reparations, I'm using uncompounded and then compounded estimates over time. The uncompounded estimates are simply the victim estimates that I just showed times $5,000, and then the compounded ones are a little more complicated. I'm using 2 different interest rates, and this simply has to do that I found an average British interest rate since 1694, that's the oldest interest rate I could find, of 4.78%, so I just took 2 amounts that surround that amount, 4% and 5%. The reason I show 2 interest rates is that just 1 percentage point difference in interest makes a huge difference in the results, as I will show in a second. So I'm translating $5,000 in 2016 dollars into 2016 pounds. Then I'm translating those 2016 pounds into the pounds at the time. So that's in 1514, that would have been £4, 98, what is that? Pence, cents? I mean, I had to translate it also into the different format. It was with, it was a complicated thing. Anyway. Then I had to determine the historical pound amount for each year from 1514 to 1866. And I multiplied in each year, multiplied that amount with the number of victims in that year and added the interest. So until 1866, I took the previous year's total, added the current year's total, and added the interest. And then from 1866 to 2016, I compounded it according to the formula that's on the screen. I'm not going into detail, just to compound it up to 2016 to make it all comparable. So here are the results. This table is again ordered in the order of increasing magnitudes, and it starts at the top with Holocaust reparations, and then estimates for uncompounded estimates at the top of the table, compounded at 4% in the middle of the table, and compounded at 5% at the bottom of the table. And the yellow highlighted proposals are the demands from African reparations activists that I just showed you. And the basic takeaway message of this table is that the African demands are not falling extremely outside of the Holocaust reparation-based estimates, but they're actually quite modest. Most of them fall in the realm of uncompounded compensation. That is, they don't even take into consideration the tremendous amount of time that has passed since 1514. Only the Truth Commission Conference's proposal of 1999 falls in the range of compounded at 4% interest rate. So again, this is relatively modest. At the bottom, you see that all the 5% compounded amounts are getting into astronomical regions, but the African demands are definitely below that. So my summary in conclusion is that both Holocaust as well as transatlantic slavery stood on shaky legal foundations or was outright illegal. And controlled for the number of victims in the passage of time, current transatlantic slavery reparations demands are of similar orders of magnitude as German Holocaust reparations. And therefore, I think that German Holocaust reparations may serve as a blueprint for eventual transatlantic slavery reparations. And in that context, to me, the most important component is that it was it didn't result from a legal judgment, but it was based on the perpetrating side reaching out to representatives of the victimized side for direct negotiations. So this seems to me a very important thing, that we as Europeans take part and take an active part in promoting reparations. So European successor states of slave trading powers should reach out to affected African countries sooner rather than later, as the effect of compounding continues until a settlement is finally realized. So thank you very much.
Presentation yours.
Okay, does this work? Yes, it does. So, yeah, Chris and I will be presenting together, and I'd like to thank you, Professor Robert Westley, and also the GAM family for hosting this conference and, yeah, giving us the opportunity to present here. We are having, yeah, like the rather difficult task now to present you an overview on the history of redress in post-war Germany, and starting with the term of redress, or German Wiedergutmachung itself. That Wiedergutmachung is a term that cannot be translated but does fit to the concept or the subject on Vergangenheitsbewältigung that was mentioned earlier yesterday. Moreover, trying to contrast the laws and the legislative amendments for redress for German victims to the characteristics of redress for foreign victims. And one has to raise the question, who is a victim, and how the definition of victims of Nazi crimes changed throughout the years. And also there have been different ways of compensating in the two German states. So on the one hand, the Federal Republic of Germany in the west, and the German Democratic Republic, the GDR, in the east. So the East-West conflict, so the Cold War, had an important impact on many aspects of compensation, which is just a single example that shows, I think, very well the importance of acknowledging the political and social historical context of redress in Germany. And by pointing that out, if we have a look at the title of our panel, so the German model, asking the question if we can really talk about that, if there is something like a German model or model at all, especially when we're looking at the whole time of 45 years between the end of war and the German reunification. From an international perspective, German handling of historical mass crime can be seen as precedent. It can be considered as a setting of new standards in handling mass crimes, first with establishing international trials for at least Nazi perpetrators, and second with compensating some of the victims, as we will be pointing out here. So the previous usage of reparation law was questioned after the Second World War, since the crimes were transnational and had a whole new dimension concerning the atrocity. And Chris will go on now talking or giving you the historical context of that atrocity. Do you want the...
Yes, this is something I would like to show you. This is a poster which was posted all over Germany in 1945 after the concentration camps were liberated. Some of these pictures are from Bergen-Belsen and from other camps, showing basically mass graves of different victim groups. It's not just it's always the question how we frame the term Holocaust, if this just includes Jewish victims or also many other victims. We estimate that there are about 13 million civilian victims of the war. So people who were killed not in the course of actually direct warfare as soldiers, but people who were killed as slave laborers, as members of minorities, Roma, the Jewish community, but also handicapped people. So there are many other victim groups which we would also looked into here. This is just to illustrate one victim group, which is a fairly large victim group. These are the people who were forcefully sterilized in Germany since 1933. You have a page from the Legal Gazette here from spring 1933, when the law, summer 1933, when the law on hereditary hygiene was passed. And you have a stone commemorating the victims of forced sterilization. We estimate that until 1939, until the beginning of the war, about 200,000 people were forcefully sterilized in Germany. It's interesting that it took until 1998 before the decisions to forcefully sterilize people were repealed. And it was argued immediately after the war that forceful sterilization was not a specific Nazi crime and was therefore also not eligible to compensation, as forceful sterilizations had also existed in other countries. This is, of course, the Nuremberg laws, which show you the idea of a racial utopia, the idea that the German population could be classified in 4 categories, so-called full Jews, mixed people of first degree, mixed people of second degree, and German-blooded people. And then you have rules on who could get married to whom. These were the definitions which became decisive when it came to deportations from Germany and most parts of Western Europe. The situation in Eastern Europe was a bit different. And this is another aspect I would like to point out, which is, I think, a specific issue of the Holocaust. This is the degree to which the Holocaust was framed into legal terms, at least when it came to the deportations from Germany and Western Europe. This is the 11th decree on the Reich citizenship law of the 25th of November 1941, where you see a Jew who has his ordinary residence abroad cannot be a member of the German state anymore, so the loss of citizenship. And then in section 3, the assets of those people who lose their citizenship are basically confiscated or expropriated by the Reich. And they are to be used for the solution of the Jewish question. So eventually they are to be used for getting rid of the Jews, which at this point in November 1941 already meant deportation and mass killing. These are just 2 sort of iconic illustrations. One is a map of the Baltic countries, which was attached to the Stahlecker report, sent to Berlin on the 31st of January 1942, so 11 days after the infamous Wannsee Conference. It shows Estonia, Latvia and Lithuania. Estonia is already Judenfrei, meaning there are no Jews left on Estonian territory. In Latvia, more than 35,000 people have been murdered. In Lithuania, 136,000 people, and in Belarus, more than 41,000 people. And the other picture is a picture from the so-called Lily Jakob album, an album which the SS had made about the arrival of Hungarian Jews in May 1944 to Auschwitz. This is another depiction of how Nazi propaganda looked at its own colonial space. Poland and the western parts of the Soviet Union were to become a colonial space, a so-called Lebensraum im Osten, a life space in the east. And the general assumption was that the Slavic people were so-called subhuman beings. They were not considered to be equal at the level of the so-called Germanic populations, which also justified their mass exploitation as forced laborers during the war, but also the mass starving of Soviet prisoners of war. The numbers vary greatly between 8 and 11 million people who were eventually deported to Germany in the later stages of the war, since 1942 to 1944, in order to work in the war industry. This is a propaganda picture in Polish, suggesting that work would be glorious in Germany with the rising sun, you can see there. And this is another picture from a shipyard in Bremen, where they were building submarines after an air raid. You can see that it has been heavily destroyed. And you see the people in their striped sort of pajama jackets having to do the cleanup afterwards. And this is contrasted with a quote from the London Debt Agreement of 1953, in which Germany managed to settle its wartime debts, where they basically managed to postpone the settlement of claims until the time when a so-called peace treaty would be concluded. This peace treaty has never been concluded, according to the official position of the German government. But you can assume that the 2+4 treaty, which was concluded in 1990 after when making German unification possible, can be considered as the peace treaty. But this shows you also that this issue had been postponed for a long time. What happened in 1945? Total surrender. Germany was divided into 4 zones. Nazi legislation was repealed. This is the building where the Allied Supreme Council was residing. It's the former Kammergericht, the Upper District Court of Berlin. Measures were taken in the wider sense of reparation. Actually, we use the term reparation in its narrower sense. The Nuremberg trials, Thomas has already focused on this. Denazification, an effort to actually try to classify German society according to the degree to which they had been involved in crimes into 5 categories. This is a so-called clearance certificate, and at the same time you see already that there is great opposition against this. This was never something which German post-war society easily accepted. This is a poster from the FDP, the Liberal Party, which calls for end to denazification, end to deprival of rights, and to basically depriving us of our possibility to vocalize ourselves, no more second-class citizens. The general mood in Germany was to forgive and forget. These are 2 amnesty laws at federal level. There were also amnesty laws at state level. In fact, when you look at this one, this is the Federal Gazette number 1 of 1949. Germany had just been created as a state. This is page number 37. In fact, the 3rd law, which is to be found in the Federal Gazette, was an amnesty law. So after the Constitution and the electoral law, the first law they made was an amnesty law, and this is another amnesty law from 1954. This shows how the churches protested against transitional justice. This is from 1950, 5 years. And they say, how long? How long shall there still be people behind barbed wire waiting to get home? How long shall we still see people being in a situation of arbitrariness without rights? How long do we still have to do forced labor in the abroad? And this is calling for the right of the perpetrators to gain back their dignity. This is a picture of Adenauer and McCloy, the US High Commissioner. The US High Commissioner always stressed that he could measure democratization in Germany also by the willingness of actually granting reparations. So Adenauer's quote, which you have quoted, might not have been voluntarily, because there had been serious pressure by the Allies to actually call for reparation. On the other hand, McCloy was willing to basically revoke most of the decisions which were taken not at the main trial in Nuremberg, but at the successor trial. Clemency was passed even to the heads of Einsatzgruppen leaders who were all released from Landsberg prison, the latest in 1958. So by 1958, there were no more prisoners of the successor trials in prisons. I will not go into this, but this is another issue which is important, I think, in the context of our discussions. Verjährung means statutory limitations. The big question of the remoteness of the crime. Under German criminal law, by May 1960, the only crimes which were left to be persecuted was murder, so premeditated murder. Yeah, manslaughter expired or fell under statutory limitation. So if these crimes had not been investigated until then, they were basically not longer under consideration. This is a quote from the Central Jewish Council, which shows in 1950 that the situation was everything but satisfactory. Yeah, there was actually great despair among the Jewish community about the state of affairs and the unwillingness of the German administration to provide redress. So I'll pass on to Katrin again.
I don't know how much time is left now. About 6 minutes. Great. So just shortly to the term or the concept of Wiedergutmachung. As I said, this is a term that cannot be translated, but if you try, it would mean something like to make something good again or to repair something that has happened in the past. And this sounds quite naive, and so does it in German as well. So this term was and still is criticized. It was criticized in the 80s when former redress was re-evaluated by the younger generation, and the critique has not changed until today. So Nazis' crimes cannot be repaired and cannot be made good again. This term can be seen as highly belittling. Nonetheless, it is still used in German scholarship and in the academic field, since it collects all the different aspects of redress, of compensation. And there it is. So these are the aspects I just mentioned. So first, it would be the restitution of assets stolen and withdrawn by the Nazis. Second, the compensation for intrusion upon Lebenschancen, meaning chances in life concerning freedom, health, and professional advancement. Third, the special provision in civil service and social insurance. Fourth, rehabilitation. And fifth, international and global agreements. And with a look at the time, we will be focusing on the first 2 points and also on the global agreements.
Yeah, time is is valuable. Just this one quote, this is Article 8 of the Paris Reparation Agreement. I think it's interesting. This is an international agreement. In Paris, there was a conference of the victorious powers, excluding the Soviet Union, but also of the countries which were allies of Germany. So Hungary, Bulgaria, Romania, Italy, and Finland were at the table. And there was the question, what should happen with the gold which had been seized in Germany? Among this gold, and this is also mentioned here, the non-monetary gold. You can imagine what non-monetary gold means. This was often the gold taken from the tooth of the people who had been murdered in the gas chambers or in the mass shootings. Germany agreed, and you have already mentioned this, the Luxembourg Agreement. You have two quotes here from Ben-Gurion and from Adenauer. which showed a willingness to actually come to the table and negotiate. This resulted in an agreement. I still have the old dollar. I didn't convert this. So Germany paid the sum of 3 billion Deutschmark, which at the time were 700 million US dollars, which went into the building of the State of Israel, and 450 million marks to the Claims Conference. And I think this is another interesting aspect. Since there were not many survivors of the Holocaust, 6 million people had been murdered, Jewish organization formed a conference, the so-called Claims Conference, which became the negotiator with the German government throughout the decades which followed. It's interesting also that the Luxembourg agreement was only passed narrowly by German parliament. Restitution, Katrin mentioned this. There were two restitution laws. One was an Allied legislation, and then there was a German restitution law, which was only passed in 1957. Restitution was limited basically to immobile goods. The volume which it reached was about 17.5 billion Deutschmark at the time. But it had a sort of discriminating effect for people who wouldn't choose restitution in naturalia, because they would receive a Deutschmark at the conversion rate of the Reichsmark, which was very unfavorable. It was a 10-to-1 rate. So those people who wouldn't choose to get the house back in Berlin or in Hamburg would have to deal with this much lower sum. And eventually the London Debt Agreement, which I already mentioned, which had big repercussions on the question how forced laborers would be compensated. And I will pass on to, and there's another aspect which was sort of prepared by the London Debt Agreement. These were the bilateral agreements Germany concluded with countries which had been occupied or whose assets had been seized by Germany. 971 million Deutschmark were paid to these countries. First, the Eastern European countries were excluded. This only changed in 1975 when Poland benefited from a larger agreement on 1.3 billion Deutschmark being paid in a social security agreement. And after German reunification, also these efforts were extended to the East. This was based on the doctrine of sovereignty of states. So individuals couldn't claim reparations from Germany, but they had to address their reparation claims to the governments of the states where they were living in. You will still see that there is quite a strong difference between what somebody in Poland or in Ukraine would eventually get in terms of compensation than from what somebody in France or Belgium would get as a compensation. Also, when you look at the magnitude of the victims. A gesture of reparation, I think an important gesture, was in December 1970 when Willy Brandt, he himself a social democrat chancellor, had been in exile in Norway, kneeled down in Warsaw at the ghetto memorial in order to apologize for the crimes Germany had committed, of which he was not part. He had been an immigrant, so this was a very powerful gesture. East Germany is a different case. We had been asked to look at the two Germanys, which makes it very difficult. In East Germany, there are two quotes which we have presented here. There was also an anti-Zionist campaign. Oh, yeah, 1 minute. We prepared for 30 minutes, that's why. Where you can see that in the course of the Slansky trial in the Czechoslovak Republic, also in East Germany, measures were taken against Jewish members of the party who were accused of being representatives of a Zionist movement and of US financial oligarchy, which was trying to basically encroach upon the German economy. So you sometimes see that the Nazi anti-Semitic vocabulary was actually replicated only just a couple of years later, basically 8 years later, in the East German propaganda. East Germany didn't consider itself a successor state of the German Reich and has therefore always basically refuted any claims being made against East Germany. This only changed in the late 1980s, shortly before the country disappeared.
Okay, I wanted to go further into detail to the Bundesentschädigungsgesetz, the federal compensation law. I tried to make it short, so in the Bundesentschädigungsgesetz, I will abbreviate it to BEG, was the first nationwide restitution law, and it became applicable in 1953. And part of the law was a definition of victims who must have been persecuted for political, racial, or religious reasons. And this definition was set first by a representative of the United States of America 10 years before that law. On a conference on the Bermuda Islands covering regulation on Jewish refugees from Europe and the question who was acknowledged as a refugee and who was not. Basically, the same criteria was used in the BEG defining victims of Nazi crime. So even at this early point, it becomes quite clear that no matter how the definition of victims of refugees was interpreted, so many individuals who we would acknowledge as victims today were not part of that definition and thus not liable for compensation. For example, homosexuals, I think we will hear about that in the next presentation, but also so-called asoziale, meaning people that were not fit to the German Volksgemeinschaft, so-called criminals, victims of forced sterilization, and the murder of disabled people and forced laborers also. So the focus in the early years of restitution was on Jewish and political victims. There were 2 amendments on the BEG, on the Bundesentschädigungsgesetz, and I would just briefly talk about the last one. The final version made it possible to reopen former rejected cases, made that reopening possible. So this underscores the fact that compensation was a process affected by many different factors concerning the definition of a victim of Nazi persecution, and these factors were the result of political decisions and developments, especially caused by Cold War politics and also the dissociation to the GDR. And in addition to that, social change regarding values and progress in medical and historical science also had an impact on that legal interpretation. Just like to give you 2 short examples. For example, in psychiatric research in the 60s, there was a new trend set concerning the acknowledgement of psychological harm. So the interpretation of harm in terms of psychological health changed and confirmed trauma and psychological harm as a result of Nazi crime, so consequently widening the definition of compensation for intrusion concerning health. And another important group that was persecuted before and even after the Third Reich in some places are Sinti and Roma. So the BEG took them into consideration as victims, but a Supreme Court ruling from 1956 excluded them. So the judges of the Supreme Court stressed that Roma and Sinti were persecuted for their asozial, so antisocial and potentially criminal behavior, and referred to an order given by Heinrich Himmler in 1943, deporting Sinti and Roma to Auschwitz. So according to this definition, the Sinti and Roma were not persecuted before 1943. So the fact that they were persecuted, imprisoned, and killed before that date, was thus ignored. And after this amendments, the application of both groups did rise. So just to come back to the question if there's a German model or not, I think it's important that we see the whole term of redress as a process. And the reason why some victims are not acknowledged is often an ongoing stigmatization after the Second World War. For some of the victims even today, like the so-called asoziales, so antisocials, are still mainly not acknowledged today. And additionally, most of these groups did not establish lobbies or other organizations that were able to give them a voice and a position in the public perception and discussion. And actually, for a long time, those victim groups were called forgotten, which is, I think, highly misleading term, since they were less forgotten than actively excluded out of the process of compensation. Also, actually, by other victims, talking about the political victims who were included in the whole process on the planning of the Bundesentschädigungsgesetz, and expressed very often quite clearly that they did not want it to be mentioned together with asocial and criminal elements. So yeah, I think we definitely do not have time for the conclusion, but I think we both look forward to the discussion later, whether there, if we can talk about a model or not. Thank you very much.
So I would also like to thank the organizers for having us here, and thank you for still being here also. So my paper aims to give an overview of the process of constructing a memory of the homosexual victims of National Socialism in East and West Germany by homosexual rights movements in the 1970s and the 1980s, and the state responses to the claims for the recognition of the status of victim. It would be an overstatement to say that the claims for reparation have ever been fully answered by either states, even the West German one, and even after reunification. This is partly due to the important amount of controversies regarding how to qualify the persecution of homosexuals under National Socialism. It is adequate thus to affirm that the diverse interpretations of the status and the persecution of homosexuals under National Socialism impacted strongly on the claims for recognition made by homosexuals and on the way those were dealt with. The claims for reparation for homosexual victims of National Socialism were never fully satisfied in Germany. Though the process of recognition can be considered partly successful in the West and after reunification, this is partly due, I argue, to the institutionalization of the homosexual movement and to the fact that the Green Party, Die Grünen, attracted many homosexual activists and became, to a certain extent, a tribune for some of the claims made by homosexual rights groups. In the East, even though the question of recognition was central to the mobilization of the movement in the 1980s, the focus was rather stressed on the process of creating a memory. It is important to state here, however, that recognition for victims of National Socialism was generally more difficult to obtain in East Germany than it was in West Germany, as we briefly saw before, and so that the difference between East and West regarding the recognition is not typical to the homosexual case. However, I think that the history of the construction of a collective memory of homosexual victims of National Socialism and the process of reparation claims has took a different form and raises different issues than other process of reparation claims in post-war Germany. So I will briefly now give an overview of the debates regarding the recognition of homosexual victims of National Socialism in divided Germany. So as the historian Jake Newson shows, even though the years between the 50s and the 70s were relatively silent regarding the persecution of homosexuals under National Socialism, it was not a complete silence. The first associations of victims of National Socialism emerged in 1945 in Berlin. the status of victim of fascism, Opfer des Faschismus, required for the claimant to be included in a strict definition. We already also heard about that before. So a victim of Nazism was officially designed as a person persecuted because of his or her race, religion, or political belief. So this definition excluded homosexuals per se. Obtaining the recognition of victim, as Angelika von Waal states, led to gain easier access to food, housing, and jobs that were much needed in post-war Germany. Reparations law were more limited in East Germany. As the historian Steven Schröder, in his study on reconciliation, shows, some victims were, however, recognized in the East before than they were in the West. He also shows that Jews were treated better in the West than they were by the restitution laws in the GDR. The demand for recognition for homosexual victims had already been raised in 1949 by the East German sexologist Rudolf Klimmer, who petitioned the West German Alliance of the Persecuted by the Nazi Regime, the Vereinigung der Verfolgten des Nazi-Regime, and he received the answer that it was at the time unclear that the Nazis saw homosexuals as opponents. The VVN, so the Vereinigung der Verfolgten des Nazi-Regime, refused to include homosexuals as they did not consider them as part of the anti-fascist resistance, so they were not considered as having anti-fascist activities, and that was framed as a condition to be granted the status of victim. As the paragraph 175, which is the paragraph that criminalized homosexual relations between men, was still enforced at that time and was even kept explicitly by the West German Federal Constitution Court based on the idea that homosexuals were not victims of typical Nazi injustice. Homosexuals were not included in the West German Federal Indemnification Law, which we just talked about before, the Bundesentschädigungsgesetz, so they were not included. And I will cite Clayton Wisnett, who writes, the West German government made no apology to the homosexual men and women who had been incarcerated in Nazi camps. The legal establishment viewed them as criminals who had been justly punished. For homosexual movements in East and in West Germany, the reference to the homosexual victims of the National Socialist past represented an important trigger for the mobilization process. It became possible for the question to emerge concretely after the reform of the paragraph 175 of the German Penal Code punishing male homosexuality. The paragraph 175 criminalized male homosexual activity since 1971. It was reinforced by the Nazis in 1935. So this paragraph was reformed first in the GDR in 1968 and then in 1969 in the FRG. However, the suppression of this paragraph should not be understood as a total decriminalization of homosexual relations. In the GDR, the paragraph was replaced by a paragraph 151, which criminalized same-sex practices between men or between women under the age of 18. As in the FRG, the paragraph 175 remained a penal sanction against same-sex relationship with a minor, which was at that time younger than 21, and male prostitution. In 1973, in the FRG, the age for same-sex sexual acts sank to 18, while the age of consent in case of heterosexual intercourse was 14. This reform was an important trigger for homosexuals to organize, and the first homosexual rights groups appeared on both sides of the wall. So I will briefly give an overview of the movements on both sides of the wall. In the FRG, homosexual activists started to organize themselves and formed the Homosexuelle Aktion West-Berlin, HAW, in 1971. Women separated from the group in 1975 and formed their own group. For the homosexual movement in the FRG, the film von Rosa von Braunheim, nicht der Homosexuelle ist pervers, sondern die Situation, in der er lebt, which we could translate by, it's not the homosexual who is perverse, but the situation, in the situation in which he lives. This film was described as a trigger by the activists. The film premiered in West Berlin in 1971. Braunheim claimed that lesbians and gays should be proud of their lives and sexualities and advocated for the radical rejection of the injunctions to fit into the heterosexual world. In East Berlin, the Homosexuelle Interessengemeinschaft Berlin, the first East Berlin group, which is also the first organized homosexual group of the Eastern Bloc, was created by the two activists Peter Rausch and Michael Egert in 1972, after the visit of the part of the movement from West Berlin, in East Berlin. The HIB, although formerly illegal, organized several activities and meetings from 1972 for 7 years. Because of its illegality, the HIB could not be as vocal as the HAW, and this is a big difference. In the West, the movement evolved freely in the context of a lively gay scene. Nevertheless, this should not make us underestimate the importance of the HIB, whose members, in spite of the scrutiny of the government, remained active and sometimes successful. In the 1970s in the West, other groups rapidly emerged. As in the East, the HIB remained the only group of the decade. In the 1980s, in East Berlin, though, groups multiplied under the protection of the Protestant Church, those working groups, which were named Lesben in der Kirche or Schwule in der Kirche, were really the ones who tackled the question of rehabilitations of the victims of National Socialism. Thus, if the question emerged in the 70s, concrete memorial actions were undertaken in the 80s on both sides of the wall. Generally speaking, the reference to crimes committed during the Nazi era which was strategically used by the New Left in the West, and I quote Dagmar Herzog, as a moral battering ram to advance sexual liberation. Important debates surrounding the exact way to qualify the deportation of homosexuals in the concentration camps were undertaken in West Germany. To summarize here, the debates aim to think about how to characterize the Nazi homosexual politics and to what extent it should be assimilated to the persecution of the Jews. Broadly speaking, and as Jake Newson states, most historians agreed in saying that homosexuals were not systematically persecuted and that there was not a plan to exterminate homosexuals that could be compared to the final solution. This narrative competed to a certain extent with the claims of the gay rights movement for the recognition of the status of victim. The pink triangle, which was worn by homosexuals in the concentration camps, was adopted in 1975 in West Berlin as a distinctive sign of the homosexual movement. For homosexuals who wished to legitimize their claims and to find support from the New Left, the reference to the Nazi persecution was strategically useful. The pink triangle eventually became a symbol of the gay community, the male gay community, in the 70s in the West, in the context of a growing importance of the gay liberation groups and in a general context of a struggle to establish a gay memory. Moreover, the pink triangle was meant to show continuity in the oppression of homosexuals. As Eric Jensen explains, the pink triangle also symbolized a continuum of legal persecutions from the Nazi era to the post-reform in 1970s. Jensen rightly insists that the whole also used the pink triangle in order to show itself a credible victim of National Socialism and create political links to other radicals and presenting gays as fellow victims of Nazi persecution. So I will now briefly comment on the actions and state answers to those claims. So in the 1980s, the answers to the claims of the homosexual right groups in the FRG and the GDR took a different form. This can partly be explained by the process of institutionalization and integration of the homosexual movement in the West that exposed the movement to a very different state reaction. On both sides of the wall, the process of memorization went through commemoration tours at the former concentration camps. In the 1980s GDR, attempts to the recognition of the homosexual victims took the form of a direct confrontation with the state. Lesbians were pioneers in the memory process. Women from the working group Homosexuelle Selbsthilfe and Lesben in der Kirche organized a visit at the former Ravensbrück concentration camp in March 1984. The women deposited a wreath in memory of the women of the former Ravensbrück concentration camp. This is what they wrote, especially our lesbian sisters. And they also wrote a few words in the Gold Book. One day after the visit, the wreath and the text in the book both disappeared. The women filed a formal complaint on the 20th of March 1984 to the Ministry of Culture, who answered that it was the fact of being active in the public sphere as a sexually motivated group that was the problem. Some women of the group Arbeitskreis Homosexuelle Selbsthilfe Berlin and Lesben in der Kirche reorganized another visit at the Ravensbrück camp 1 year later, and in order to avoid any problem because they were performing an action as a group, all 11 women decided to participate individually. On the planned day of the visit, the women were arrested by the police, verbally assaulted, their passports were confiscated, and they were heavily interrogated. They were sent back home without being able to perform the visit. The probability that this kind of incident would happen could be sufficiently intimidating to prevent any kind of public commemoration. However, the lesbian opened the way, and the next visits, once a year in Ravensbrück, suffered less repression from the state, who eventually stopped from refraining the commemorations and even gave some formal authorization. Some working groups in the East in the 1980s centered some of their discussions and actions on the theme of the persecution of homosexuals under National Socialism. On the 30th of June 1984, 2 visits were undertaken by homosexual groups at the memorials of the Sachsenhausen and Buchenwald former concentration camps. As the West German homosexual movement got more and more institutionalized in the 1980s, claims for their specific rights were progressively integrated into the programs of political parties. In 1978, homosexual working groups were created in political parties such as the Social Democrats and the Liberals. The interests of homosexuals were set in political parties with the foundation of Die Grünen at the beginning of the 80s, which attracted homosexual activists in 1983. The Liberal Democrats inscribed homosexual rights in their program in 1981 already. Specific claims as the one for the recognition of the homosexual victims of National Socialism found an institutional answer already starting in the 80s that was not found in East Germany. The pressure of the Green Party and homosexual movements led to the recognition of homosexuals as forgotten victims. In 1985, the Green Bündnis 90 member of Parliament Waltraud Schopp, in a speech in which she denounced the patriarchal structure of the political German system, asked the federal government to recognize the persecution of homosexuals by the Nazis. At the occasion of his discourse for the 40th anniversary of the liberation in 1985, the president, Richard von Weizsäcker, mentioned homosexuals as victims of National Socialism. From then, memorials were constructed in concentration camps and in several German cities. Memorial stones were placed at the former concentration camp of Dachau and Neuengamme in the mid-1980s, the Frankfurt Angel in 1984, in Cologne in 1995, and a memorial was set in Berlin in 2008. More substantial changes at the time of the new coalition, Social Democratic and Green Party, were made in 1996. On the 7th of December 2000, the federal parliament officially apologized to the homosexual victims, and their criminal sentences were erased. In the summer of 2017, a new law entitles now homosexual victims of the paragraph 175 for compensation of €3,000 plus €1,500 per year passed in prison. So as a conclusion, the process of constructing a memory and claiming for reparation by homosexual rights groups and the rejection of a complete recognition in both states, in East and West Germany, are results of complex interactions. Here I have argued that the institutionalization of the movement in the West has participated to the partial recognition of homosexuals as victims. However, other central dynamics should be taken into account to understand more accurately the difficulty to obtain recognition. Angelika von Waal points to the centrality of the question of sexuality and the reluctance of West Germany to take into account homosexual demands. In other words, we should take into account how sexuality and the treatment of homosexuality since the Third Reich in Germany played an important role in the demands of homosexuals. Moreover, the way both states dealt with victims of National Socialism in general also needs to be taken into account into the analysis, as much as a concurrence for recognition between the different groups of victims. To summarize, if the political and symbolic contexts have to be closely looked at in the analysis, I have argued here that the dynamics produced by the movement themselves played a crucial part. Thank you. Yeah.
Hans, on one of your slides, you showed it appeared that the I guess the Catholic Church, or that there was Jesus Christ was on the slide, and that my impression was that was part of the groups that were excused, I guess, in the negotiations from having any liability for collaborating with the Nazis, and I guess I'd be interested in knowing more about the role of the Catholic Church in terms of their facilitating not only anti-Semitism and being passive in their collaboration, but also whether they had anything to do with the anti-gay, lesbian, homosexual, because of their most recently they've maintained this position of being opposed to gays and lesbians, LGBTs in this country, and they have been very much opposed to equal rights for a long time. And I just wanted to know what you have to say about that.
Yeah, the role of the churches is complex. I mean, the Catholic Church generally considered itself to be opposing to the Nazi state. There had been a concordat being concluded in 1934 after the model of Mussolini's agreement with the Catholic Church in 1929. But nonetheless, the Catholic Church was treated with contempt by the Nazi regime most of the time. There had been resistance from within the Catholic Church against the euthanasia killings, the killings of handicapped people, especially the Cardinal and Bishop of Münster, von Galen. He was one of the few priests who was publicly speaking against the euthanasia killings, also compelling the regime to react to this in summer 1941 and stopping euthanasia killings officially. But after the war, both churches were very it started very quickly that they called for amnesty and for forgiveness. I mean, the Catholic Church, there was Bishop Hudal, who was in Rome, who was providing former Nazis who were trying to flee to Latin America, to Argentina and to Brazil with papers, with new papers, in order to basically start a new life in Latin America. And there was a big campaign by both churches during the last of the American trials in Nuremberg, the Wilhelmstraßen trial, which was directed against Ernst von Weizsäcker, the father of Richard von Weizsäcker, whom you mentioned, who was a state secretary in the Foreign Office, and who was not matching the idea of the Nazi perpetrator. He was a distinguished representative of the German elites, already the elites before 1933, and he didn't match the idea of this ugly, sadistic, campsite perpetrator. And this is almost stereotypical for the way how perpetrators were dealt with, and also how society represented by the churches here reacted to this. Once efforts were undertaken to actually reach out to the desk perpetrators, to the elites in the administration, in business, this mobilized a lot of opposition, and the churches were very vocal in their opposition against this. The Protestant church only in the late 1950s made a Schuldbekenntnis, a confession of guilt on their complicity in the crimes of the Nazi state and basically turning the other eye to many crimes. The Protestant church was divided in two churches during the Nazi time. There was a sort of schisma. In the Catholic Church, this remained a controversial issue because the general self-perception was that they had been persecuted themselves by the regime. And that also the Pope in Rome was basically in a situation of siege by Nazi Germany. Regarding the situation of homosexuality, I think you might be better placed to answer this.
Well, I'm actually more specialist of the GDR than of the war and of the FRG, but in the GDR, I could say more about the role of the Protestant church, which was actually very important because it's in the Protestant church that the homosexuals were able to organize, as the Protestant church gave protection from the state for the peace movement and different social movements, among them the homosexual movement. Yeah.
I guess, what was the basis for the Nazis believing that homosexuals were morally inferior to Aryans or whatever? I mean, that they classified them with Jews as to be persecuted.
I think one has to understand that other than, also if you look at Roma as gypsies as a group, there is a persecution which starts much earlier, which is, of course, gains a new quality during the Nazi state, but homosexuality had been officially criminalized in the National Penal Code since 1871. So basically, there had been a relaxation during the Roaring '20s in some parts of Germany. In Berlin, you would find many places where homosexuality was openly lived and celebrated, but it was considered by the Nazis as a phenomenon of decadence and deviation. Yeah, basically a phenomenon of the of liberalism, which was considered to be dangerous for the community of the people, for the resurgence of a national state. There was another issue which was quite important within the Nazi party. The head of the SR, the assault troopers, Röhm, was outed to be homosexual. He was murdered in summer 1934 in a big night of long knives where more than 90 leading politicians were murdered by the Nazi state. Among them also Röhm and his closer affiliates. And this was also then portrayed by the Nazi regime, by the propaganda, to show how dangerous cliques of homosexual men were. They were seen as an endangerment of the state. They supposed that they would actually lead to a coup d'etat, which was not the case. This was a fabricated idea. But it's interesting that the Federal Ministry of Justice in West Germany reproduces this idea when the decriminalization of homosexuality is discussed in the big coalition agreement on reforming the criminal statutes, they still use these kind of arguments. Yeah? They still speak about a clique of homosexual men as being a potentially dangerous thing for the Republic. So it's quite interesting sometimes how these topics are replicated, and you will find that the Adenauer years, Adenauer was Catholic. Yeah, he was opposed to the Nazi regime, but they were a time of restoration in many ways. For example, in civil law, the principles of getting a divorce on the fact that the marriage had deteriorated, something the Nazis had introduced in Germany only in 1937 in order to make divorces more easy. So they wanted to have people have more children, basically, was repealed in the Federal Republic, and it was necessary again that you had to prove the guilt of one party against the marriage, which was much more complicated. There are many other cases with regard to women's liberation, for example, where women had benefited from the war and the absence of men. This was the same in all economies in war, and this was systematically repealed in the 1950s. So there was a climate of restoration which was particularly difficult also when it came to the issue of living homosexuality. I don't know if this answers your question, but...
I think also that the idea of homosexuality as being dangerous for the stability of the system is not something typical of National Socialism anyway. And yeah, for example, when I'm looking at the GDR communist countries, and I mean, it's a continuum. It's not something very specific, in my opinion.
Before I ask my question, I just wanted to add a little point, which you also mentioned as a reason for the persecution of homosexuals for the Nazis. This was a natalist politic of the Nazis, that men and women should make as many children as they could, and homosexuals were considered as unproductive in this meaning. But my question, I'm perfectly know that it was absolutely impossible for you to speak about all the aspects of this problem in Germany, but I wanted to ask you about the situation now. Does it mean that all the aspects, that all the dimensions of reparations are now closed, are finished, which doesn't seem to me to be the case? There's a question of the Ghetto-Renten, etc., and about the way to continue on another level. For instance, the creation of foundations like Stiftung Erinnerung. So what's the idea behind this, and what are the means to continue this policy?
Yeah, we had to cut ourselves very short because it's a complex history, and in fact we didn't get to the past 1990 years, which are quite interesting, not only because it was the first time where the demands of victims behind the former Iron Curtain were addressed, but it was also the first time where the issue of compensating forced laborers was eventually addressed. And this was something which was also not happening voluntarily, but this was brought about by different circumstances. There was a big class action against Switzerland and the Swiss banks and Swiss insurance companies about unclaimed Holocaust assets and insurance premia. And this was followed by another big class action campaign in the US against big German companies who hadn't compensated slave laborers. In the late 1980s, Volkswagen, VW, and Mercedes had started to compensate slave laborers on a voluntary basis, as they always insisted. But the agreement with the creation of the foundation Erinnerung, Verantwortung und Zukunft, the EVZ, and the creation of a fund which was half paid by the German taxpayer, the other half was paid by big German companies, was only the result of the danger of class actions being brought in the US and the need for the federal government to come to the negotiations table. And this was also a Green Social Democrat federal government which was more receptive to such demands than the previous government, but one still has to bear in mind that in 1998, when Gerhard Schröder became the chancellor, he still spoke about a punto final, a final full stop under the past. Basically, this was something German politicians had been demanding since the late 1940s. Yeah, they always wanted to draw this final line under the past, and it never worked. Yeah? The past always re-emerged like Hamlet's ghost, who rises from the grave. And there are still ongoing issues of compensation. You mentioned the Ghetto-Renten. The Ghetto-Renten is an interesting case because this is not really an issue of compensation, but in Germany, any kind of labor contract has to be included in the social security system. So you cannot employ somebody legally without paying to the social security system. And even if you do, it is assumed automatically that you have to contribute to the social security system. So what happened was people who had to work in the ghettos, had to do forced labor, they had a claim against the social security system in Germany. These claims, of course, for a long time were not being brought forward, especially as most victims were in the East, behind the Iron Curtain. You have to imagine that, especially, for example, Ukrainian forced laborers, when they survived the war and when they came back in 1945, they often suffered a second wave of victimization because the Soviet administration considered them as traitors and collaborators. So they had to go through camps where they were investigated. Many of them were sent to Siberia, and many of them were keen on hiding the fact that they had actually been doing forced labor in Germany. They burned their papers. They destroyed all evidence which they later needed in order to prove that they had a claim to such social security payments. This was a very complicated situation, and unfortunately, the social security system in Germany is still doing, or seems to be still doing, a lot in order to delay these cases until the last claimants die. Yeah, this is a fact. It's not made easy for people to actually claim a pension under the regulations for Ghetto-Renten. And there's, of course, the whole question of whether claims are hereditary, whether there is the possibility for second-generation victims to claim. We just spoke about the damages, or the idea of damages changing also through the idea that traumatization was an issue which was only recognized in the 60s as a potential damage. Yeah, before psychological damages were not at all recognized. So there are still open issues. I don't think it is terminated yet.
Thank you guys for your presentations. So I just want to say one of the things I've been doing is live blogging.
One more?
Uh-huh.
There's still one more question.
Oh, no, I'm not ending it. I was asking a question. You guys are now so afraid of me. Oh my gosh. Thanks. I was actually asking a question. Oh my gosh, I was trying to participate. I've been live blogging this conference on my Facebook and social media, and probably others have as well. And there's a whole bunch of jealous professors across the country who wish they could be here to hear everything everyone has said. So I want to commend everyone. So I'm not a historian by training. I was raised by a historian, but my disciplines are philosophy and law and gender studies. So one of the things that some of the this collection of presentations has kind of revealed to me is the way in which others perceive the German response to redress and reconciliation has been a product of German ideology that's been exported globally, right? So in the US context, we are like, oh man, I wish we could get some like German redress for the problem of slavery here, or some, we have a response where we're serious about this conversation. Thomas started his presentation with this very heartfelt mea culpa about how the state's response made him feel. It's almost aesthetic, right? In people our age and this generation, that this is what Germans do. We are responsible for what happened, and we feel certain things about it. And so one of the things I kind of took away from this presentation is that first, there is not a singular German response to this horrible, unimaginable crisis. There are responses in part based upon the value of individuals, the perceived external value, and also responses based on who the German people were coerced into responding to, right? So international pressures. So that made me interested intellectually and stimulated, but also horrified. Because, and here's why I'm horrified. Because throughout the conference, I've been thinking about, the question of reparations in a comparative context, and how to bring perpetrators to the table, right? And so what your presentations actually revealed to me is that, once again, Derek Bell is right. Right? Those who are the perpetrators of wrongs and historical injustices who benefit from them will never come to the table unless coming to the table benefits them. And so,
They are pushed to
and they are pushed, right? So please tell me I'm wrong, and that there's something, because there's also the voluntariness, right? So maybe the gay and lesbian picture gives me a little hope, because here's a group that we've changed our perception of, but maybe the Germans are making it hard to even get, I don't know. But I'd like some hope, but I don't know if that's the right perception, that there are these German responses, and it's kind of a production of ideology. That's one of the things I'm taking away, because I've always, when I know Germans, they're like, well, look what we have done. Look what we've done. And then we went to South Africa and we consulted there, and it's wonderful. And I'm like, oh yes, you're very wonderful, yes. And then I feel like, I wish we were half as wonderful. But you guys are actually undermining my feeling about that, which I think is good and productive, right? But am I wrong, or can I be more hopeful? Is there a, because you guys were very neutral about it, but I feel like for a lot of us who are coming from the international and comparative context, your version of redress and reconciliation, that's what we've got. That's what we hold on to. Unless we want to go where Natsu's going, right? Let's destabilize the whole colonial endeavor. That the nation state itself in modernity is illegitimate. I'm willing to go there, I'm not afraid, but I'm wondering if we have to.
Question. I don't know. I don't think that the case of recognition in the case of homosexual victims really worked, or was really successful anyway. But I guess there is an important amount of controversies around this question about how should they be qualified. And maybe what I would like to say is that I think at least that there is still a very big invisibility of the lesbians, and yeah, it's also controversial to what extent, because they were were they persecuted specifically or not? I mean, some of them were as asocial also. So how should we think about that? And it probably has to do with intersectionality, or yeah, it's different. So yeah, I don't know. I just want to say that.
I don't think you're wrong. I think you're right in seeing that. And like for me, I'm also an educator at a concentration camp memorial and working with students and also with adults. And I've recognized that in the last months or years, has been a change in society when it comes to commemoration. So this, what you mentioned, that Schlussstrich, so putting a line under that, people started claiming that, especially with that new right-wing party, right-wing movement that has established in the last year. So people want to rather think about the good sides or the nice parts of German history. So this has led to all that commemoration and memorials, and I mean, Germans are to be there's that term of Erinnerungsweltmeister, so the champion of commemoration, the worldwide champion. And yeah, maybe this is like a new movement going against that. And yeah, do you have something to add?
I tend to be very cautious because the post-1990 narrative of Germany is built on this idea to have risen from the darkness of the Nazi past, like phoenix from the ashes, to the light of a national law-based, interdependent, heavily export-oriented economy. And if you look at the way how this was achieved, it's everything but linear. And you have, I mean, for example, the memorial I'm heading was only opened in 1992, so 2 years after German unification, and under great international pressure, because there was a lot of fear that a reunited Germany might emerge as a Fourth Reich in the center of Europe, as the dominating power. And showing that Germany was dealing with its past was a way to get a sort of blueprint for showing that Germany had become democratic, that it was willing to embrace international norms, that it was not a country to be feared by its neighbors anymore. So this was a way of reducing the level of fear and apprehension among neighbors. But it also shows you that there had been no Holocaust memorials in Germany until then. There had been concentration camp memorials. Bergen-Belsen was also an important site of the Holocaust, but it was not built as a death camp. It was at the very late stages of the war. It really became a Holocaust site. This is something which I think needs to be, and when you look at the compensation for forced laborers, it really took the danger of class actions before something started to happen. And you do have the phenomenon that groups who were better organized, especially Jewish victims who were propped up by the state of Israel, as a sort of powerful negotiator, were in a much better position than people who were marginalized because of homosexuality, because of having been considered asocial, for having been people with mental illnesses, for example. For example, even today, we just made an exhibition on the year 1938, which was a sort of turning point, a year where things radicalized. And with Jewish victims, you always mention both names. You mention the first name and the second name. This is not the case for asocial victims or for mentally impaired people, because there's still a feeling of shame within families that they had relatives who belonged to these categories. Yeah? And there's still, and we have to negotiate with the data protection officer whether we can actually put these names in an exhibition or not. So there's a I mean, I'm not saying, and there's a lot of Opferkonkurrenz, competition among the victims, even between gay men and lesbian women. Yeah, they are sort of fighting for the status of who can actually claim to have been subject to more severe persecution under the Nazi state. Katrin mentioned the case that the political resistance to the Nazi regime didn't want to be mentioned at the same level with people who were still subject to marginalization in post-war Germany. For the Roma, the so-called gypsies, it took hunger strikes by one of their chief activists, Romani Rose, before this was officially acknowledged by the West German government, and before eventually also a monument was created in the city center of Berlin, close to the Reichstag. In fact, when you look at there's a sort of trail of monuments. There's the monument to the murdered Jews, which was opened in 2005 only, yeah, so this is also a relatively recent event. And then you find the other monuments to the gay victims, to Roma victims, to the victims of the euthanasia. And now there's a big discussion whether there will be a monument to the victims from the East, which is also complicated because the Poles don't want to be remembered together with the Ukrainians or with the Russians. So it's... I mean, from a perpetrator perspective, it didn't matter, yeah. But for the victim groups, this is quite an important issue. Still one question? Yeah.
Is this working? No.
Oh, there's two questions. Okay.
There's another question.
I think Kenny was first.
Yeah.
He has been holding up his arm.
Okay, I promise I'm not trying to shut it down. So, at least not yet while there are questions. I actually have a question of my own, if I could have a point of personal privilege. And I guess it's sort of spurred in part by Suru's reaction to the panel. Because, I mean, I think the panel, for me, the panel did start off with a level of skepticism about German redress, which from my position seemed also a little bit discouraging. I mean, I was so proud to have discovered this book by Christian Pross, Wiedergutmachung, and yet we start off by saying, you know, this term is pie in the sky, and it doesn't really have the kind of seriousness and resonance that perhaps we associate with it from a German perspective. And nevertheless, I think about other terms that we get from the German redress process that have been important in my own thinking about this issue. Terms like Vergangenheitsbewältigung that was mentioned on yesterday's working through the past. There's no equivalent in English American discourse. Historica strike is another term that there's really no equivalent in English American discourse around redress. Stoppelsteiner. We're having a discussion about how to, here in New Orleans, but also across the nation, really, about what to do about Confederate iconography. and what to replace it with. And here in New Orleans, so far, we've had a proposal from the outgoing mayor, who was responsible for getting rid of some of the Confederate statues, that we should replace the statue of Jefferson Davis, the President of the Confederacy, with an American flag, which my reaction to that is, well, that might be good for those who were opposed to the removal of Jefferson Davis, but it doesn't speak to those who were always objecting to that statue. So I still have some guarded optimism that some form of the German model is going to be useful in other struggles. It certainly has been something of a paradigm and a beacon for people who have been unable to make any progress towards even having a serious discussion about redress. And so I guess my question, however, is it seems to me that there are two major points of transition in recent German history. One would have been the end of the war and the division of Germany into two states. The other would be the point of unification. And so I'm still very curious about the panel's view of how useful is this notion of transitional justice in the context of thinking about redress or reparations policy in those two circumstances. Because the most recent discussion that I'm aware of, just as an example of what's happening on the LGBT issue in Germany, is that there's a serious discussion about whether there should be what's being described as rehabilitation, but from where I sit, reparations for gay people. And even though this country, before Germany, was able to move judicially towards marriage equality for gay people, it's beyond my imagination that there could ever be any discussion in this country about reparations for gay people. So I think that guarded skepticism is perhaps appropriate, but I still think that what the Germans have been doing and experimenting with is something that that is helpful, and valuable for those who find themselves in circumstances where their efforts towards achieving social justice have essentially hit a wall. So I'm just curious about what you think of that.
Shall we collect?
Collect the question, maybe?
Sure, go ahead.
Yeah, thank you. I'm curious about how you explain the conspicuous difference between Germany and Japan regarding reparations. In my opinion, I think the U.S. role is closely related to this matter. On the one hand, regarding the Holocaust reparations, the Jewish people played a very important role in the American society. So the U.S. government supported, in many ways, their movement. On the other hand, in Japan, shortly after the end of the World War II, Douglas MacArthur gave up prosecuting the emperor's responsibility. And then, in the early 1950s, due to the inconsistent U.S. policy, just in front from facing the Cold War situation the A-ranked, top-ranked perpetrators are liberated from the prison, Sugamo prison. For example, the Prime Minister Abe's grandfather, Shinsuke Kishi, Prime Minister Kishi, is in charge of deporting slave laborers from China or Korea, but he himself was liberated by from the Sugamo prison by the inconsistent change of the U.S. government. So, that's my opinion. So, I'm curious how you explain this big difference between two countries.
We take one more question. And then
Was there another?
Yeah, that would be also a point for a discussion of 1 hour or many hours. But I think another very important point you have evoked it is the role of the civil society in Germany through all these years, and the fact that there were the years of silence. So the first generation after the war grew up without knowing anything, without hearing anything. When they became young adults, they were revolting against the system. 1968, not only in Germany, but in Germany with a specific dimension that they were suddenly asking. They wanted to know. They asked the parents, what have you done? Where were you? Etc., which was at this time very more a theoretical question. But then in the years after that, started to not only to ask on a theoretical level, but on a practical level, what happened there, what happened here, and trying to appropriate this history by themselves, Geschichtswerkstätten, etc., and also combined with something which might be considered as very Protestant, having this attitude of feeling guilty and wanting to assume this culpability of the parents, which is no longer the fact, but it was, I think, a very important phase. Then going to the idea of a responsibility, so less moral, but being responsible for this past, which led to a lot of commitment, of engagement in the civil society. And this is what I think is very important, because you spoke about all the international pressures or about the actions of victim groups, but I think the commitment of the civil society is a very, very important element. There are so many examples. The stumbling stones, for instance, is not something which top down, it's something which is down up, like a lot of other initiatives. I stop here because I could speak so long.
Well,
one last thing.
Okay.
There's alcohol waiting for us in the multipurpose room.
Oh, I'll announce it. Hi. So there is alcohol waiting for us in the multipurpose room, and also food, so hopefully it'll be fun. I wanted to let you guys know there will be 2 buses back to your hotel, one at 6 and one at 7. So depending on how you feel about the alcohol in the other room, you might want to have a quick drink and go back and rest. You might be tired. You might not want to be with us. You might want to have a lot of debates and have a few drinks at our full bar for a while and then go back at 7. So you have options and choices in New Orleans. So I just wanted to announce that. And I think we should thank our panel. No. Oh, we're going to listen. Oh, I'm going to sit down.
Back to questions.
Sorry.
Yeah, we were also hoping for the alcohol at the bar, but we still owe you answers.
Ending things now.
Yeah, maybe just very briefly, I cannot say anything about Japan because just don't know enough about that, but maybe just to add to what you just said, Jura, I think it's important that there has been the change from people feeling guilty to feeling responsibly, that generational change, but this is also leading like to new questions. So that the question is commemoration enough, and what do we get from commemoration saying, yeah, this was very horrible and this must not happen again? Like everybody would agree with that, of course, but to go a little bit further and ask, what do we have to do so this does not happen again? And I think these are questions that cannot be easily answered, but are even more important, and also getting more important, having a look at the memorials, which do not only do historical education, but also go further to human rights education and in terms of prevention.
Okay, so I don't know if I will answer anything, but I was thinking about your comment, Gerard. Well, the commitment of the civil society, and in the case I've been looking at, for sure, it's also the capacity of the people to organize and to have a voice that will make things work or not. And I think that in that case, even though there was no reparation formally, I mean. Yeah, for paragraph 175, there is reparation, since last year. And the memorial, I think that the gay community, the male gay community in Germany can be strong. And there are resources that maybe the women didn't have also compared. Yeah. And I was also thinking about your remark on being skeptical or not. I don't know if I'm skeptical, but for sure, I think that at least Germany has done a very important work on memorization and on history, because I didn't grow up in Germany. I grew up in Switzerland, and it was really part of our historical program when we were kids at school. We always heard about the Holocaust a lot. Not so much about slavery, not so much about other issues, but Holocaust we really heard about it a lot. So, I think for that I would not be skeptical.
Since everybody's waiting for the bar, I will try to be brief. To Robert's question, 45, 1990, yeah, there were significant differences. I mean, in 1945, Germany was defeated. Yeah, there was an allied supreme government. There were different zones. There was the effort of the Nuremberg trial. There was the effort of denazification. Also, the first restitution laws were allied legislation. And this sort of leads to the parallel with Japan. This all got very quickly, I think there were many positive initiatives, positive efforts, but when the Cold War started, basically the momentum started to be lost, and the focus was on stabilization and also to recycle the old elites. And there are studies now on the public administration, the ministries in Germany at federal level, which all show that despite efforts of the allies to take disciplinary measures against members of the civil service, they're all back on. There's a law in 1951 being passed by Parliament unanimously, which grants people access to civil service and to pensions again. Efforts of the Allies to reform the civil service are basically brushed aside by the young Federal Republic. And you have the situation that by 1953, throughout all ministries, about 60% of the staff had been members of the Nazi Party. And some ministries more than during the Third Reich, which is interesting. But this doesn't say that these people were still Nazis. This is the other thing. Many had changed, had seen the benefits of a democratic state, maybe. So this is also something which has to be taken into account. So it's difficult to speak about a renazification, but similar to Japan, we have the situation that the old elites basically manage very quickly to repenetrate the system. In 1990, the situation is very different because one state takes over the other. And they have the resources, there are enough judges who are looking forward to get an even better post in East Germany, there are enough people for so it's almost, I mean, many East Germans perceive this as a colonial occupation, But it also meant that you could cleanse the civil service, yeah, because you had alternative people available, which wasn't the case in 1945. There were few people coming back from emigration. And there was generally the assumption that the mistakes which had been done after 45 should be avoided after 1990. So, for example, also when you look at the judicial trials, the trials done by German courts in order to persecute Holocaust crimes are really disappointing, one could say. I mean, until 1988, there were only 178 convictions for murder. Yeah, you have to imagine that the core group of perpetrators of the Holocaust consisted of roughly 200,000 people. Even though not all of these have survived the war, there are only 6,800 cases being adjudicated successfully. So this shows you the discrepancy. In 1990, there is the general demand that, for example, the Mauerschützen, these were the soldiers guarding the wall between the two Germanys, had to measure their behavior against natural law and should have, even though these were 19-year-olds at the time when they were doing their service at the border, should have been able to see that complying with the Grenzgesetz, the law on the border of East Germany, was against international law and against natural law. So there was a completely different attitude also towards these cases. With Japan, I think, it's in both cases, the Cold War can be felt very strongly. In Germany also, there's a big debate about rearming Germany, which works in both senses, because it works in the sense that the resistance in Germany is recognized against Hitler, which was still considered by most Germans as traitors. Yeah, this is also interesting if you look at opinion polls from the early 50s, and you would ask people, you all probably saw the Tom Cruise film on Operation Valkyrie, the attempt to topple the Hitler government on the 20th of July 1944. Many Germans, if asked in the early 50s, would still say these were traitors. Yeah, they were stabbing their dagger into our back at a difficult time in 1944. But having to have a positive image for rebuilding an army, and also for offering a narrative which was a positive integration, also for former Nazi officers, which were needed to rebuild the army, you had to come up with this myth of a very important resistance in Germany, something which was also used in other states as a strong issue. I'm not entirely negative about this, but I think one should still be cautious about brandishing this as the model to follow, because it's a very twisted road. Yeah, it's not a linear road which leads to positive results, but it's a very twisted road, and it's not always voluntarily. This is also has to be, and one has to bear in mind also that many Germans considered themselves as victims. There was a lot of victim competition between those who had been driven away from the East. I mentioned yesterday the Lastenausgleichsgesetz. So I think the compensation measures adopted by the Federal Republic in the early and mid-1950s wouldn't have been imaginable if not at the same time measures had been taken to address the loss of property for people who had been driven away from the East. So this was also an important context for this.
Okay, I think now we should thank our panel. And I'm only going to ask if there are any remaining organizational questions. Otherwise, we should just retire to the multipurpose room and imbibe.